All right. Good afternoon, everybody. I'd like to welcome you to the Oklahoma Indian Bar Association's 2025 CLE entitled McGirt 5 Years Later. The Promise Continues. And of course, that's a reference to Justice Gorsuch's um, uh, reference in the opinion in order to address um, the promises that were made back in 1866 as part of the treaties, initially with the Muskogee Creek, and of course the other of the uh, 4 or 5 tribes. Couple of logistics. My name is Arvo Mikkonen. I'm the president of the Oklahoma Indian Bar Association, and we've assembled a very talented group of speakers. They're going to go until approximately 5 o'clock today. Some logistics. If you are wanting to get CLE credit in Oklahoma, we will take care of filing that for you. If you're from another state, then we will send out a certificate of completion. And once you get that certificate of completion of the hours that show 3 hours of regular CLE and then 1 hour of ethics, then you can take that document and go to your local state bar in order to see if they will grant you those credits. We're not able, unfortunately, to do all the filing that's necessary for people from states other than Oklahoma. So if you are from Oklahoma, we need to ask you to make sure and do this at the very end, because in the past, we've had people delay sending that in. And if you delay sending it in, it will hold up everyone's approval process, because the bar wants to receive all of the participants' names and their bar numbers at the same time. So don't forget to do that. Don't wait to send it in later, because you'll hold it up for everybody. So what we're going to be doing is there are going to be a number of code words. I will announce what the code word is. So you will need to send an email. Send the email to Oklahoma Indian Bar Association at yahoo.com with all the code words that we give during the seminar. The other thing that you need to do is give us your name as it is listed with the bar. Some people have names that are different than the listing with the bar. So whatever your official name with the Oklahoma bar is, we'll need that. We'll need the code words. And most importantly, we will need your OBA number. So again, I will remind you again at the end, please send in your name, your OBA number, and the code words, and then we will make sure and get the credits for you. This is being recorded, so anything that appears in the chat will be recorded. Any questions that we address also will be part of the recording. We hope to have a later showing of this seminar, and perhaps those that are not available today to participate will be able to sign in. So hopefully we're going to be doing that. Ultimately, the Oklahoma Indian Bar Association also has a YouTube channel, and we generally will upload all of our CLE programs after a couple months have gone by to that YouTube channel. And that's part of our effort to try to educate the public about Indian law issues and other things that the lawyers in this state are addressing. So those are some of the logistic questions. If in the meantime you have connectivity issues or you lose contact, send me a text message to 405-420-9912 and we'll try to address them. Or you can email Oklahoma Indian Bar Association at yahoo.com. Okay, so we've got a lot to cover. Also, for the written materials, there is a Dropbox. And much thanks to Joe Williams, one of our other OIBA officers, who has set up that Dropbox, because, of course, there have to be written materials, not only for your education, but also for the bar to approve our credits. And so the link to the Dropbox was emailed to you, but if you didn't get it, it's also in the chat. Click on that. It also contains an evaluation form that we would hope that you would take some time to fill out, as well as the lengthy bios of all of our presenters. We're not going to spend a whole lot of time going into all of their various accomplishments and accolades and publications and prior positions that they've had. But if you want to learn more about our speakers this afternoon, you can certainly go to see their complete bios. Okay, so we're going to go ahead and get started with our first presenter, and that is Robert J. Miller. I always call him Bob Miller. He's an expert in federal Indian law, American Indian international law, American Indian economic development, constitutional law, civil procedure. He's an enrolled member of the Eastern Shawnee tribe. Sorry about that. Chief Justice for the Pasqua Yaqui Tribe Court of Appeals. He also is a judge on a number of other tribal courts. He's a professor of law at ASU and is the Willard H. Petrick Distinguished Research Scholar, which is a mouthful. And he's also the faculty director of the Rosette American Indian Economic Development Program at ASU. So I will go ahead and turn it over to Bob, and we will go until approximately 2 o'clock. And your first word for your CLE credits is Quapaw, like the Quapaw Nation. All right, I'll turn it over to Bob.
Thank you very much, Arvo. I'm trying to open my PowerPoint slide. I hope you can all see that. I'm delighted to be here. Thank you for inviting me. I've been involved with the McGirt case from, of course, the day it was issued, as all of you have been, but I'm doing this from afar. I was born and raised in Oregon. My mom was born in Oklahoma, went to boarding school in Seneca, at the Seneca Indian School in Wyandotte, Oklahoma. You probably all know the Eastern Shawnee tribe's in the very northeast corner of Oklahoma, but I was born and raised in Oregon and now 13 years here at Arizona State. On July the 9th, 2020, my wife woke me up that morning. She's a lawyer. She said, "I think the tribe won that case." And I was quite shocked. As you can see, the title of my talk and the title of the first article that I wrote on McGirt, I called the case a bombshell. I don't make too many predictions. I don't pretend to be a prophet of the future, but I knew what an impact this would have in Oklahoma and maybe across the country even, but particularly in regards the Muskogee Creek Nation. And then later, as the Oklahoma courts applied this same analysis that the Supreme Court adopted, you have 6 or 7 or 8 other tribes' reservations re-recognized. My own tribe's reservation is only 14,000 acres in northeast Oklahoma, but we were allotted in 1888. And we are waiting for way over a year now for a federal district judge to sign what looks like a slam dunk decision that our reservation is re-recognized. But can't even guess as to why it's taking this long. But anyway, so my wife says she thinks the tribe won this case. I was shocked. I went online, got the case. The opening line on the far end of the Trail of Tears was a promise. Arvo already referred to that. I knew the case was a win because what's the promise? It's the treaty. The book that I co-authored on McGirt, we borrowed that, a promise kept. And so we borrowed Justice Gorsuch's line. I have commented in my book that perhaps he's a poet, a judicial poet now, because that is quite a line to start the opinion with. So my job here is to set out the case and what the court did, and then we're going to hear from people talking about the consequences. Let's see. Let's advance. Okay. I can't give a talk anymore on any Indian law topic without addressing George Washington's Savage's Wolf Letter. Maybe you've no doubt seen it, but maybe not for decades. Or maybe you've never seen it. And I just wish every American would read it and get the same chill that I do when you see the advice that General George Washington gave to the Articles of Confederation Congress. He was invited to give them advice. We had just signed the treaty with England to end the Revolutionary War. The existence of the United States was now guaranteed, at least by England in the international sense. And so the Congress asks George Washington, what do you think? What should we be pursuing? What should we do? So he writes a 4-page letter. And you can get this letter from the National Archives in 1 second. If you type in George Washington and that date, September 7th, 1783, you will have the original letter that George sent to the Congress. On page 4, he gets into how Congress should deal with the native nations. And so, what happened in Oklahoma, what happened across the continent and to tribes is no surprise because it was the goal of the United States. So, read that. What did I have trouble reading it because so many things block me seeing my own screen. But anyway, he says Indians will retreat as we advance. That's the cheapest way of doing it. He said war is expensive. Policy and economy point strongly to being upon good terms and attempting to buy Indian lands instead of doing it by force of arms. And then here's where the letter gets its name, Savage as the Wolf, because he equates Indian human beings to the animals. He says, what happens to the animals? They retreat. And then he says, well, the gradual extension of our settlements will certainly cause the savage as the wolf. And I've saved the key point for this last bullet point to retire, both being beasts of prey, though they differ in shape. So even if you've seen this letter before, a few years ago, decades ago, I hope that makes a chill go down your spine that the United States was hunting Indian peoples and we were their prey. I'm going to try to get out of the sun here. It's always nice to have the spotlight on you, but I'm trying to stay out of the sun in my own kitchen here. So is it any surprise what happened in Oklahoma? You all know the history of Oklahoma 10 times better than I do. The boomers, the Sooners, the land runs, the invasion of Indian country. This was going on in George Washington's time, the 13 colonies, the Daniel Boones, invade Indian country, cause conflicts, kill Indians, take their lands, acquire their lands. And yet that's exactly what George Washington foretold. Do it peacefully if we can, do it by treaties if we can, but the United States is going to get all their lands. So, gosh, my talk's over. Thank you, Arvo. I rest now. Okay, I better not. Usually I give this talk to a lay audience, and so I have to explain some of these things. So I can go through these next 2 slides very quickly. You all, of course, know the Supremacy Clause and that the treaties and the U.S. Constitution and the federal laws are the supreme law of the land. But what do we know? And we learned this really, I think, for the first time in what are called the Chinese exclusion cases in the 1880s, that Congress could abrogate a treaty with China that the United States was already a party to. And what does the Lone Wolf case say in 1903? The Congress can also abrogate Indian treaties. Gosh, if we can abrogate international treaties, surely Congress can also abrogate Indian treaties. So that's what McGirt's about. And that's what the case that preceded it, that the 10th Circuit decided in Murphy in 2017, which I'll discuss. Maybe I should just discuss that now since I brought it up. Let's see what the next slide is. Again, I don't have to spend much time with you all. There's some argument over how many treaties there really were. I think the better argument, and the ones that we can count up that the Senate ratified and the president proclaimed, is 375. Treaties are contracts. Read it like a contract. The parties have to fulfill the terms or suffer certain penalties or pay certain contract damages. And then, of course, we all know the Winans case. What is a treaty to begin with? I have my classes memorize this line. Let's see if I can memorize it right now under the gun. A treaty is not a grant of rights to the tribes, but a grant of rights from them, a reservation of those rights not granted. So what your tribe, my tribe, and the other tribes across the United States, when we signed, our ancestors signed treaties, we were giving up certain claims to land, certain assets, maybe certain rights, but we kept what we did not give up. So that's what the state of Oklahoma and all of you are dealing with today. What do these tribes, what rights and powers do these tribes have within now their newly re-recognized borders? And I use that word very carefully. Reservations were not recreated. Reservations were not restored. Their borders were re-recognized, something that Oklahoma had fought for 114 years. And we all practically had come to believe in it. I mean, I taught Indian law now for 34 years, I think. Used to always say, well, there's only one reservation in Oklahoma. All the other Indian lands are allotments, 18 USC 1151C. And the only reservation we thought there was the Osage Reservation. Well, you all know in the Irby case, was it 2010? The 10th Circuit held that the Osage Reservation had been, and I forget if it's diminished, but I think it was completely disestablished. So there's a case that sits out there that now stands in contrast to McGirt. And in contrast, I'm pretty certain that tribe's thinking about how to bring these issues back up. Okay, so treaties. What about the Creek? Of course, I think my tribe was one of the first tribes to remove. We were in south central Ohio. We signed a treaty in 1831 under the new Removal Act to remove to where we're located today in northeast Oklahoma. The Creeks, as all the other tribes, the 5 big tribes, were under these same pressures. And so the Creeks signed a series of treaties. I find this very interesting. Did the Creek leaders speak English? Were they lawyers? But they knew that they were willing to move if the United States would guarantee them lands in perpetuity in the West and even use the phrase, we want the fee simple title. So the tribal leaders had learned, were that educated and that smart in negotiating the United States. We don't want to move again. We want lands in guaranteed ownership to be protected. So the Muskogee Creek majority of the tribe does move. What is their treaty? What did that first treaty say? A permanent home, solemnly guaranteed by the United States and to govern themselves. Now, here's another point I find how brilliant those leaders were. They say we never want to be under the law of a state or even a federal territory again. They knew what had happened to them in the state they were located in, and how President Andrew Jackson said, I won't protect you from state law, you better remove. So the Creek said, okay, we'll move. We want the fee simple title. We want a promise that we will never be under state or territorial law again. Obviously, those promises were breached, weren't they? There's the Indian Territory, and then ultimately the state of Oklahoma. Once the Creek arrived in where they're located today, a new 1833 treaty to define the lands that would be their was their reservation. And later, 20 years later, another treaty. No portion of Creek lands ever be inside a territory or state again. And the Creeks have self-governance, full jurisdiction over their citizens and their property. Solemn guarantees the supreme law of the land under Article 6 of the Constitution. Would the United States fulfill those promises, and would Oklahoma recognize and live up to those same promises? I can't even read the top slide. It's blocked. I think this says, so it's the 1866 treaty. So what happened to many of the tribes? We signed treaties with the South during the Civil War. My own tribe did the same. The Union troops and even the BIA superintendents left the territory. And who marched in were Southern troops. Hi, nice to meet you. And so many of the tribes did sign treaties with the Confederacy. After the Civil War, the United States saw another way to carry out George Washington's plan. Use these new developments to take more tribal lands. So at Fort Smith, Arkansas in 1866, Eli Parker, Seneca Indian, who became President Grant's head of the Commissioner of Indian Affairs, he and 2 others show up and they took us to the woodshed. You were traitors to the United States. We do not recognize your old treaties. You have to sign new treaties, and we want far more land. So the Muskogee Creek and the 4 other big tribes gave up 50% of their lands. I'll show you a map in just a moment. What I have to mention this, folks, the southern states were not punished much for the Civil War. I think we incarcerated very few people, the winning North, and there were Northern troops in the South for over a decade. But the South, I don't want to talk too much about things I'm not an expert on, but the only entities that were punished for the Civil War were the tribes. What a good example of what George Washington said. So what happened? The Creek Nation signs their 1866 treaty, sold half their land, I think for 30 cents an acre. But it was for other civilized Indians. And the part they kept, the eastern half of their reservation, would be forever their homelands. And notice I've underlined the word on the reduced Creek reservation. This is the first time one of the Creek treaties had used the word reservation. Justice Gorsuch emphasizes it just in the opinion, so that's why I'm emphasizing it too. There's no question that a reservation was established, that the tribe and the United States agreed to do that. But I also don't want to overplay this because you all know that the reservation era of federal Indian policy started roughly in 1849 in Texas and California. That was the first use of the word reservations for Indian homelands. So it's no shock that the earlier Creek treaties didn't use that word, but how important that word is in the 1866 treaty. So here's a map I'm certain you've all seen. Here's the the five big tribes. Here's the lands they ceded. I guess I could make a joke to Governor Stitt. Well, instead of complaining what's left over, you would have had no Oklahoma if the United States hadn't extorted those 1866 treaties. And then here's just another map showing more of the tribes. Also, why else do I show this one, folks? Because the most important tribe of the United States is at the very top there, Eastern Shawnee tribe. Now, I've got to tell you a joke. I was giving this talk in Miami at the Intertribal Council to the chiefs of many of the 9 tribes that are part of that entity, my own tribe included. And when I paused for dramatic effect, like I just did, the most important tribe in the United States, the chief of the Wyandotte yells out, "The Wyandotte Nation!" Anyway, I find that quite funny. Okay. Diminishment questions and disestablishment. I'm going to again move my seat because this sun is on me. Sorry about that. These are the 8 cases that the Supreme Court decided in developing how to analyze a diminishment. That's when a reservation gets smaller, or a disestablishment when the reservation is completely extinguished. I'm not going to focus on any of this. I'm certain you all know that the 4th case there, I guess it's the 5th, Solem versus Bartlett, the court developed a test and a form of analysis for how to determine when a reservation, when Congress has exercised its power to diminish or disestablish a reservation. So what is the Solem 3-part test? And this is discussed quite a bit in the McGirt opinion, and the dissent is vociferous about the fact that Gorsuch and the majority did not rely on all 3 steps of the Solem test. So I'll talk about that a little more. What did the court decide in those 5 disestablishment and diminishment cases? Well, we look for Congress's language. If only Congress can abrogate a treaty, then what did Congress say? What act of Congress said Tribe X's reservation is gone, or Tribe X's reservation is made smaller? So we analyzed the specific language. And the Solem court said, well, we know that the Congress was never super clear, and so there are other steps. And second of the Solem 3 steps, look at contemporaneous evidence. Literally read what newspaper reporters wrote. What did the tribe itself think? What did the public think? What did senators or legislators say in what might be called legislative history? Did everyone think that act of Congress that was just enacted diminished or disestablished the reservation? Now, today, we'd mostly call that legislative history. And as I'm sure we are all aware, the current Supreme Court of originalists and textualists, they don't think much of legislative history. They don't want to look at it. They're reading the text of the original document, whether it's the Constitution or an act of Congress. Well, what's the 3rd step? And this is the one that when I teach the Solem test, I start screaming usually. The subsequent history and the demographics of the region? Why do I get so upset? How does that help you understand what Congress said and meant in 1893 or something when it enacted a statute, and you're looking at what happened the subsequent 100 years? And the reason I get so upset about the demographics, American Indians are what, 1.5 to 2% of the population of the United States? What do you think the demographics will show when we mix with non-Indians? But here's a very important point I want you to remember. The court in many of these cases said allotment does not diminish or disestablish a reservation. Remember, allotment didn't change the borders of reservations. It just changed the form of land ownership inside the reservation. Okay, so with this in mind, this is what we expected the McGirt court to do. Again, I cannot see the title of my slide. This is Nebraska v. Parker. Going back just a few slides, remember this was number 8 there, and the Omaha Reservation was not diminished. The lands at issue and at question there were Indian country. Well, why am I showing you slides about Nebraska v. Parker? Well, Justice Thomas wrote the opinion. He does not very often vote on the side for tribes. But this was a 9-0 decision that the Omaha Reservation had not been diminished, even though there was a part of the reservation where the tribe had no presence anymore. The population was almost exclusively non-Indians, etc., using the Solem test. But here, as an originalist, as a textualist, what did Justice Thomas and the court 9-0 say? Mixed historical evidence, that step 2 of the Solem test, cannot overcome the lack of a clear statement from Congress, step 1. Step 3 evidence, the changing demographics, is the least compelling evidence. Okay, great. They agreed with me that, and they got mad at the same as I do about using demographics. And look what the court said, Justice Thomas's opinion. It's not our role to rewrite the Congressional Act in light of any kind of subsequent demographic history. Now, I highly like this view right now because Oklahoma and the 4 dissenters in McGirt want to talk about Solem step 2 and 3. They criticize Gorsuch and the majority very much for really just relying on step 1. So let's get to here's again Thomas saying that how government officials treated a disputed area land has limited interpretive value. Interpretive of what? Again, the act of Congress that is being relied on as allegedly having diminished or disestablished the reservation. Okay, I also am going to take a digression here, folks, because I am going to show you the Oklahoma Enabling Act. You may know more about it than I do. And your state constitution as of 1907 and still your constitution today. The United States Supreme Court in Gorsuch did not rely on this, and I read very carefully the main brief for Mr. McGirt, and I've even asked 2 of the attorneys. One, I only just caught him in the hall at Fed Bar, but I asked, why didn't you rely on the Enabling Act? And of course, he didn't have time to analyze this in great length, and I'm not even going to say what was said, but this is language that I think pulls the rug out from under the dissent's argument in McGirt and under Oklahoma's argument for the past 114 years. In McGirt, Oklahoma argues that 8 different federal statutes from 1893 to 1906 had disestablished all the reservations in Oklahoma. But I now want to focus you on what the Enabling Act said and what the Article 1 of your Constitution says. The Enabling Act, if you don't know, of course, every new area that wants to become a state, Congress has to pass an Enabling Act, and they set out certain conditions. Well, here's the Oklahoma Enabling Act in 1906. Congress was well aware that there were many reservations still in the Indian Territory and in the Oklahoma Territory as of 1906. That undercuts completely what the dissenting justices in McGirt said and the argument that Oklahoma had made. So there's the Osage Reservation mentioned, the Kansas, the Tonkawa, the Pawnee, and I love this last one because this is my tribe's reservation. The 9 Indian reservations lying northeast of the Cherokee Nation. Well, that's my tribe's reservation, the Wyandotte, the Miami, the Senecas, the Cayugas, etc. So Congress was well aware in the Enabling Act that there were still Indian nations and reservations existing in 1906 in those areas. Completely to the contrary of what Oklahoma argued in McGirt and the earlier Murphy case, and what the dissent complained about in McGirt. So, gosh, someone out there in the audience is smarter than me. Tell me later why I'm making a big deal over something, and maybe this is why the McGirt attorneys didn't argue this. Here's also the lands of the 5 big tribes were also specifically recognized. The word reservation wasn't used, but the lands that these nations still owned and lived on is expressly recognized in the Enabling Act. And the act required that a new state to be formed out of these two territories must respect the reservations, their lands, and their rights. And so what's my conclusion? Congress had not diminished or disestablished any reservations as of 1906. And that just pulls the rug out from under Oklahoma's argument. I think I have a little more on the Enabling Act here. And so one of the conditions for statehood is that Congress expressly required in its Constitution for this new state to disavow any claim over these tribal lands, Indian people's rights. And here's the rest of that. Nothing in the Oklahoma Constitution can limit or impair the rights of persons or property of the Indians of the territories. And then the rest of the clause, the people of Oklahoma must forever disclaim all right and title in lands owned by any Indian, tribe, or nation. Again, I'm puzzled why this wasn't a major part of the argument for Mr. McGirt, and even why the Supreme Court in the McGirt decision didn't rely on this. So I may be missing something, so please let me know. Okay, so here I'll just cover this very quickly. When Oklahoma does become a state, and when first Constitution was enacted, here's the language, and this is still the language today, folks. I'll let you read it. Now, did Oklahoma and the Boomers and the Sooners and the land run people, did they comply with this? No. What did the state say for 114 years? There are no reservations in Oklahoma. That just contradicts these facts and what Congress mandated in the Enabling Act. Okay, again, I cannot, my own thing is in, okay. So many people have forgotten, I guess, that before McGirt, the 10th Circuit had already held that the Muskogee Creek Reservation still existed. This is an intriguing case and was argued to the U.S. Supreme Court in 2018. Bullet points aren't working. Okay, there we go. This decision was so momentous, it took 5 years for the 10th Circuit to decide it, and it's a 138-page opinion. Wow. Well, you know why it took 5 years? Because the justices on the 10th Circuit realized how significant this case is. They were certain the Supreme Court would hear them, and so they were very careful and methodical in addressing Oklahoma's argument and reaching their decision that the Muskogee Creek Nation Reservation still existed. 30 pages of that opinion. They looked at the 8 federal laws that Oklahoma claimed, and there's the dates I gave you earlier, that Oklahoma claimed had disestablished the Muskogee Creek Res. The 10th Circuit applied the Solem test, the 3 steps that we just talked about, and said, no, Congress never diminished or disestablished the Muskogee Creek Reservation. 30 pages. They looked very carefully at these 8 laws that Oklahoma, and the reason I'm emphasizing this is these are the same laws Oklahoma argued to the Supreme Court about McGirt, and these are the same 8 laws that the 4 dissenters claimed did disestablish the reservation. So no one statute, they never claimed one statute had clear language. They cobbled together their argument from 8 separate federal laws, all of which the 10th Circuit rejected as proving disestablishment. At the Supreme Court in 2018 of the Murphy v. Royal case, Justice Gorsuch recused himself You all know he was on the 10th Circuit. He had sat on one or two of Mr. Murphy's cases that had spanned 15-year time period. The court could not decide the case. They ordered supplemental briefing and on two additional questions. Well, that alone's kind of pretty odd in the Supremes. And then they set the case over for reconsideration and re-argument the next year. That's extremely odd. Cases like Roe versus Wade, Brown versus Board of Education, Citizens United, those are about the only three cases that I know of. Surely there are others, but that the Supreme Court could not decide and set over for oral argument the next year. I have a quote from my book here from a Columbia University law professor, Ronald Mann. He said the Murphy case, and here's a quote, was the single hardest case of the U.S. Supreme Court term, the one case that the justices could not decide. So they set it over for re-argument. But okay, now I have this in brackets because we don't know why they set it over. Commentators guessed that there was a 4-4 split of the court. And you all know what a tie vote in the Supreme Court does is it reaffirms or affirms the lower court decision. So this seemed like just too important of a situation to affirm Murphy based on a split decision. The reason I'm certain that it was 4-4 was because what does McGirt end up? 5-4 when Gorsuch sits on the case. So instead of hearing Murphy over, the court instead granted McGirt, certiorari in McGirt, a state court case upon which Gorsuch could sit. Taking a look at my time. Okay. So what is Oklahoma's arguments? Again, this stupid space bar is blocking half my screen. Oklahoma's argument was those 8 statutes and the overall thrust of congressional action spread across numerous statutes had equal diminishment. But again, this is why I go back to the Enabling Act. That argument is completely false based on the Enabling Act. The United States Congress was still talking about 9, 10, 12 different Indian reservations in the Oklahoma and Indian Territory as of 1906 in the Enabling Act. Congress allotted the Creek Res, passed lots of other acts that you know more about than me, Curtis Act and others, that limited Creek government and even possibly in the future was going to abolish the Creek Nation. Okay, possibly in the future. Again, a multitude of acts, no one specific act. A sea change and chaos that would be caused in eastern Oklahoma. In both the Murphy case and the McGirt oral arguments, the extreme language that the Oklahoma attorneys used. Turmoil, upset, the sky is falling if McGirt is affirmed, or if the Muskogee Creek Reservation is affirmed. And the issue of taxes, what they claim, turmoil, chaos, would decimate state and local budgets. All adoption cases would have to go through tribal court. Oh, interesting. Yes, I write about that a fair amount in my book. One of the consequences and impacts of McGirt is now the application of ICWA in far wider areas than it was before. The sky is falling. I've got to show you folks, I have a couple pages from the Murphy brief and of Oklahoma. And I was quite surprised to see Oklahoma include this map that showed eastern Oklahoma being all Indian country. Well, why'd they do that? Because the Murphy case was only about the Muskogee Creek. And on the next page, I'm going to show you, you probably don't remember this, page 3 of the Oklahoma brief. In the brief is a photo of the skyline of Tulsa. What in the heck is that doing? A limited, you have a limited number of pages and words. Well, what's funny, at the oral argument, Justice Breyer asked a question. He goes, well, how important is this case? And he's talking Murphy. He goes, I suppose that's why that photo of Tulsa was in there, was to provoke me to ask that question. And the transcript says there was laughter throughout the courtroom. So Oklahoma was trying to make the court see and or feel how this would just be an unbelievable change in Oklahoma. And don't you dare, court, fulfill the treaty promise of 1866. Years after the decision, of course, I've been following what goes on, and the editorial board of the Wall Street Journal, they sure bought into this Oklahoma chaos theory. Here's just a couple of the editorials that the Wall Street Journal wrote. The Wall Street Journal reporters have, honestly and fairly reported the conditions, things that have occurred in Oklahoma since McGirt, but the editorial board bought into this turmoil argument. Okay, again, I can't even see the top slide. Okay, the decision itself. Well, step one of the Solem test. Oklahoma claimed the Allotment Act and those other 7 acts. What did we already say? What did the Supreme Court said for decades? Allotment is not diminishment or disestablishment. And the majority says we cannot find a explicit statement from Congress that it intended to diminish or disestablish the Muskogee Creek Reservation. Never in any of those acts that that's why Oklahoma had to rely on 8 acts, folks, because none of them said what Oklahoma wanted. And so they were trying to use the weight of 8 different acts that did impact the tribe negatively in some ways as being diminishment or disestablishment. We all know the opening sentence. Wow, the tribe won. I immediately started writing about the case. Again, I thought it might impact my own tribe up in the northeast corner, but I thought this case was a bombshell. And the very first article that I wrote, I called it that, a bombshell. And so that's even the topic of my talk today. Major impact on the tribes, the native peoples, and the state of Oklahoma and the citizens of Oklahoma. Reservation boundaries are still in place. They were never altered or removed. The entire area is a reservation Indian country under 1151A. Now, here's the key point, and the Supreme Court always tries to limit its holdings to a specific issue. They want to cabin their analysis and cabin what the case is. Or it says we were asked just whether these, well, I shouldn't have thrown in the word just, but that is what Oklahoma has thrown in there, isn't it? So I'm sure many of you are dealing with this argument, and I know the speakers after me will address these issues, so I am not going to touch that. But the court says for the Major Crimes Act, this is still a reservation for federal criminal law. Now, I'll let again the people that follow me, Oklahoma and Castro Huerta, their argument is that McGirt only applies in the criminal law arena. So I think that's totally wrong, but that is how Oklahoma is now reading it. So Justice Gorsuch, in writing his opinion, as the Supremes usually do, he restated what the issue was in McGirt, and now Oklahoma is arguing that somehow it's a reservation only for criminal purposes, not a reservation for civil law. And that's ludicrous. I just want to make 2 points, folks. Within just a few months of the McGirt decision, the Federal Office of Surface Mining wrote a letter to Oklahoma and said, all this is Indian country and has been re-recognized. You, the state, can no longer exercise jurisdiction over surface mining in what's now re-recognized as the Muskogee Reservation. That's a civil law arena, folks. And now I was going by memory. Well, Oklahoma, all their arguments about turmoil and that this case would cause a big sea change were mostly about civil issues, tax, ICWA, regulatory issues and zoning. And the dissent themselves talks about how this decision will have an enormous impact in the civil law arena too. So we all assumed that this was a reservation for all purposes. But the argument that Oklahoma is making now is that it's only for criminal law. So I'm certain the speakers after me will address that. What about Solem step 2 and 3? Gorsuch doesn't ignore it, but look, I'll let you read what he wrote, what the majority wrote. Now, under the Solem test itself, you don't need 3 steps if Congress had passed a statute that said X reservation is diminished or X reservation is disestablished. If Congress had been that clear, the Solem court would have said, don't bother with step 2 and 3. Well, that's exactly what the majority is saying here. These 8 acts that Oklahoma has pointed us to do not diminish or disestablish the Creek Reservation. And he said there's no reason to go any further. Now, I want you to think a moment. We have what, 6 justices of the court that are self-avowed originalists, textualists. They're not interested in legislative history. They will interpret as the founders of either a clause of the Constitution or the 14th Amendment or Congress when they pass an act. What was the intent? What does the text say? And they do not want to read supplemental materials, legislative history, etc. What is step 2 and 3 of the Solem test? They're supplemental legislative history materials. And so one would think, I know I'm being Pollyanna here, but one would think the 4 dissenters in McGirt, who are all self-avowed originalists, and now what's the new word? History and tradition. That you'd think they would want to read these acts as what Congress said and not look at legislative history. But they insisted on step 2 and 3 of Solem, and they severely criticize the majority opinion for not looking at step 2 and 3. Here's the rest of what Gorsuch wrote. No need to consult extra textual sources when the meaning of a statute's term is clear. So that's interesting. These 8 statutes were clear that they did not disestablish the Creek Reservation. So it's kind of a, I don't know what you call that. It was clear in a backwards way. I didn't say that correctly, but that is what Gorsuch is really talking about. So I don't need step 2 and 3. The 4 dissenters, you may not know this, the dissent in McGirt is longer than the majority opinion. Justice Roberts writes it. They excoriate the majority for ignoring history and what really happened and how hardworking Oklahomans had created cities and towns and invested money in areas, and that now it might be at risk. So that's what the majority, or the minority, the dissent, wanted to argue. I guess I just have some more language here. Let me again look at, while you're reading that, I'll look at the time. So Gorsuch and the majority say that what Oklahoma did for 114 years in violation of the law is not proper. It cannot be permitted. I underline that last part. None of these moves. So the Boomers, the Sooners, whatever, the invasions of Indian country, the theft, the probate court situation that Angie Debo wrote about in his book, Gorsuch mentions that just barely in passing. But this history of the theft of tribal lands, tribal assets, that can't change the law. He said that would be the rule of the strong, not the rule of law. And then here's just one other. We cannot allow this to happen. It would elevate long-standing and brazen injustices and reward those who are in the wrong. So the McGirt opinion is a strong statement of right and of enforcing the law and enforcing treaties as the supreme law of the land, notwithstanding what the state did for 114 years and that the federal government, the trustee of the tribal nations, allowed to happen over 114 years. Now, what did the court think was going to happen? Is there any question that this case is a bombshell? I didn't mention this earlier, but after I got so involved with writing about McGirt, my wife has said in our household, it's all McGirt all the time. So yes, then I ended up writing this book that I'm holding here. I hope you already have a copy. But anyway, I co-authored this book with the professor of anthropology from Mississippi, who is an expert and written on and studied the tribes, the 5 big tribes in the American Southeast. And she was already an expert on the history of the Creek Nation, and was delighted to work with me. And she writes the first 4 chapters in the book about the tribe's history and then treatment in Oklahoma. I love this cover too, because this is by a Muskogee artist, Johnny Diacon, and it is a painting of a Muskogee light horse police officer from 1901, and he allowed us to use that as the cover. So what did the majority think was going to happen? Well, the opinion quoted to over 50 years of Oklahoma and the tribes entering negotiations and signing cooperative agreements and compacts to address all sorts of issues. And you all know far better than me the gaming, the alcohol, the license plates, the hunting and fishing compacts that were signed, I believe, in 2016 before it's now a current issue. But here's the threat, and Gorsuch mentions this on the same page. He goes, if things don't turn out this way, if there's horrific, or not, he didn't use that word, if there's enormous problems, what happens if the situation doesn't work out? Look at that quote, folks. Congress is free to supplement its statutory directions at any time. Now, what in the heck does that mean? I think the majority was saying Congress could abrogate these reservations. So I guess the point for us as tribal attorneys or representing tribes, etc., tribes want McGirt to work out too. We don't want 30 to 50 years of litigation over every single issue. That's what I have predicted a time or two. If the state, the feds, and the tribal nations don't work these issues out through the kind of negotiated compacting that Gorsuch mentioned, if this continues to be a problem and we litigate every single issue, that could rebound to our own harm. So, I'm not representing any tribes in this situation, so I'm an outsider, but wow, let's try to settle these issues and let's not litigate McGirt for the next 30 to 50 years. So there's the threat. So let me look at my clock. I still got plenty of time. Okay. This is what I foretold. Again, the people who are following me will no doubt talk about the Strobel case, the surface mining situation that I just brought up, ICWA, and then Castro Huerta itself. So Castro Huerta changed Indian law in every state and for every tribal nation. So the McGirt case has had a bigger impact. It's more of a bombshell than even just about the topic it was about, disestablishment of a reservation. Okay, I'm not supposed to talk about the impact, but in case no one else covers this, and I do teach economic development issues, so I just want to, well, I've already made this point. My own tribe's reservation might become recognized, so that is pretty darn exciting, at least for me. But here's some issues on economics that I just have 2 slides, and then I'll be done. In fact, I think I'll even be done a little early, Arvo. These studies came out in time for me to include in the book. The book that we wrote together came out in January of 2023. So as just before the index, the last page, we have an epilogue, a 2-page epilogue, and we highlight what these 2 studies found. So Oklahoma said the sky was going to fall, the world was going to end if the Muskogee Reservation was re-recognized. And so here's 2 studies that I think are very dramatic and we should all know about. Here are 2 professors, one of which, as a lawyer, had represented Oklahoma at some stage of the McGirt litigation early on. Michael Velchek, I think is his name. They studied county-level employment differences, county-level gross domestic product, and daily financial data for public corporations for the counties in Oklahoma that were impacted by the Murphy decision from 2017, and then by McGirt. And they found, you can read that, they found no economic difference between eastern counties that are now re-recognized as being Indian country versus Oklahoma counties in the West. And that's now, when I first was citing it, I was citing just the paper posted online. Now, of course, it's been published in the Yale Journal of Regulation. Here's a second study by 2 economics professors from the University of Wisconsin. I do not think this has been published yet, so you have to go to that web link. They studied Zillow home sales and prices, and then the evidence on this oil well drilling, new oil well starts in the eastern Oklahoma counties. Excuse me. in contrast to the western counties that were not impacted by Oklahoma. And you can read that. Now, to be fair, I find this kind of interesting. They say, in fact, more wells were drilled more quickly in eastern Oklahoma. So if you owned an oil company, why do you think that happened? Maybe I shouldn't give my dumb opinion, but anyway, some companies who thought, what will McGirt do? Let's drill wells today. So interesting that at least these two studies show that the economics impact has been nothing, or if minimal. Okay, and I think there's the end. There's the cover of my book. It's out of focus, but blue's my favorite color, so it's a beautiful cover. Now, Arvo, I'm 5 minutes early. Do I still get paid the same amount?
Yes, of course you do. Are there any questions? Anybody want to put a question or two in the chat box? One thing I'm gonna, and you kind of alluded to it, Bob, was in a negative impact. Castro Huerta, of course, affected jurisdiction not just in eastern Oklahoma for the reservations over there, but it affected jurisdiction nationwide. And one of the strange things that happened right after McGirt took place is, at least through the press accounts, there was this, I guess, mistaken impression that McGirt only applied to the 5 tribes. And everybody now, of course, knows that that's not the case. Really, in your outline of cases involving, starting with Matz versus Arnett and Seymour, the Seymour case, and Dakota versus District Court and Solomon versus Bartlett. Really, McGirt is just another way of interpreting when reservation boundaries are going to be recognized and when they're not, if Congress hasn't spoken. Now, of course, in Oklahoma, our reservations, we have 3 categories. We've got clear instances where reservation boundaries were specifically erased. If you look at the Poncas and the Otoe, Missouri, there's a language that says basically, those boundaries are hereby erased, abolished, and the areas that formerly were a reservation are now attached to Kay and Noble counties. And then you have, the 5 tribes and some of the tribes up in the Northeast where Congress didn't address it at all. And then you have some of the Western tribes that are kind of got swallowed up in these old cases like Solomon versus Bartlett or Dakota versus District Court, where it didn't really say. There were some allotment agreements. Congress never really erased the boundaries. But and so that's a long way of leading us into our next word, but recognizing, like you're saying, McGirt really wasn't just about the 5 tribes, wasn't just about the Muskogee Creek Nation, but was about interpreting when boundaries exist and when they don't, following allotment. So I'm alluding.
Yes.
Oh, go ahead.
McGirt was cited in a 7th Circuit case literally within the first month or 2 that it was out. There was a question, I forget the tribe, but there was a lawsuit about whether part of that reservation had been diminished. And McGirt, and so its form of analysis was used immediately.
Exactly.
So McGirt can have a bombshell impact for other tribes in other states too.
Right. And that tribe is our next code word, and that's the Oneida tribe in Wisconsin. We had a couple people sign on late. So you might have missed the very first code word. Again, you need to put these code words in an email to Oklahoma Indian Bar Association at yahoo.com at the conclusion of this seminar to get your credits. So the first word was Quapaw. The second word is Oneida, and that involved the Oneida reservation in Wisconsin. And following, like you just said, the analysis in McGirt, they recognized that the Oneida boundaries were still there. So, all right, I think we have one question, perhaps. There was a question, why does the government still use the word Indian instead of Native American? And why Creek instead of just Muskogee? Okay, I'm going to save that second question for our next panel, since we have Attorney General for the Muskogee, formerly Muskogee Creek Nation, now the Muskogee Nation. They would probably be the best to address that particular issue. And then the first question is, why does the government still use the word Indian instead of Native American? What do you think, Bob?
Well, this is the answer I always give. Most Native people that I have ever encountered use the word Indian. So we still use that word. I read one editorial in my entire 35-year career, Arvo, somebody arguing we shouldn't use the word Indian, but they also didn't like the word Native American. So I don't know what your experience has been, but that is the phrase we use. Many of our tribes have the word Indian in the official title of the tribe. So I don't know the question, are you inferring that the use of the word Indian is somehow politically incorrect? And so my answer to that is no. Native American, fine if you want to use it, but I think most Indians say the word Indian.
Yes, I would agree with you there. And the other issue that comes up quite frequently is the fact that a lot of the federal statutes say Indian. They don't say Native American. And sometimes Native American has been construed to include, Native Hawaiians and some other groups, Pacific Islanders, that wouldn't be categorized as Indians. So again, thank you very much, Bob. Appreciate your insights. And again, I have a copy of your book. It's on the shelf over there. So we'll continue to make reference to that, and maybe we can get some of those on our website when we get that up and running. So thank you again. I'm going to move right along into our next panel. And our next panel is going to have two speakers. Initially, we just had one, Jerry Wisner. But we also have, fortunately, been able to get Philip Tinker, who has been involved very closely with the litigation that's been going on involving the Muskogee Creek Nation Reservation since July of 2020, when the McGirt decision was made, and actually even before that, back when Murphy was the cutting edge of the law. So Jerry Wisner is a citizen of the Muskogee Creek Nation. She's the Deputy Attorney General. She's also a United States Marine. She's been a prosecutor for over 20 years in Indian country with various tribal nations. She's a 2001 graduate of Oklahoma State University with a BA in Political Science and an American Indian Studies certificate. She got her JD and Native American Law certificate from the University of Tulsa College of Law in 2003. Philip Tinker is of counsel with the law firm of Kanji and Katzen. He has represented a number of different tribes, most recently been involved with a lot of different cases that are, those of you have recognize, involving the Muskogee Creek Nation, Carpenter versus Murphy, McGirt, and as well as some of the other matters that have developed since then. And we hope that they will address some of those things, such as the settlement with the city of Tulsa, following some of the litigation that's been going on in federal court in the Northern District. Philip is a citizen of the Osage Nation. He got his JD in 2011 also from the University of Tulsa College of Law. And he, prior to that time as a law student, was an intern with the White House Council on Environmental Quality. He also served as a law clerk for 2 years for an Eighth Circuit judge, William J. Riley. And he resides in Tulsa within the boundaries of the Muskogee Creek Nation. So we're going to give them a little bit more time. So we're going to go from 2 o'clock to 3:15. And again, that second word is Oneida. And we'll go ahead and turn it over to Jerry and Philip, however you all want to divide up your time. It's up to you. Thank you.
Thank you, Arvo. Can you see my presentation?
Yes, it is up.
Okay, good. Um, J, Jerry Weisner, Jaho Tifkados, Muskogeo Benagan, Keith Leiden Gomez. My name is Jerry Weisner. I am excited to be talking with you about many of the things that we're seeing on the ground in real time as a result of the McGirt decision, and also a lot of the things that we are seeing in the aftermath of McGirt. But I also want to give an opportunity for Philip to make some introductory comments.
Thank you, AG, and thank you, Arvo, for that introduction. I am Philip Tinker. I am an Osage citizen. I have recently had the privilege of moving back to Tulsa. I grew up in the area, did attend Tulsa Law School, been away for quite a few years, and I'm living back here now. And most of my work at the moment, I'm very privileged to be working with A.G. Weisner and the Creek Nation to try to secure the legal benefits of the McGirt victory in the case that my firm and I have been working with the nation on. From the beginning, we represented the nation as amicus in the Murphy and McGirt cases from the 10th Circuit up to the Supreme Court, and now we have a number of litigation efforts ongoing to affirm and secure the nation's jurisdiction in the post-McGirt regime now that the reservation has been recognized. And before we move on, I'm going to ask, I don't know if this is Arvo or somebody else, is there a way for AG and I to both have our videos up in addition to the presentation? I think we're hoping and anticipating doing a bit of back and forth and having this more of a conversational dialogue than a straight presentation, and being able to see each other might facilitate a little bit more of the conversational tone that we're hoping that we're going to be able to get here. If not, we can certainly make do.
Okay. Well, and I think as I have it in presentation mode, one of the things that I also wanted to keep be cognizant of was any kind of questions. However, because it's in presentation mode, I can't see the chat. So, Philip, can you see it?
Yes, I can pull it up. So
So,
if you want to run the presentation and I can kind of moderate the questions, I think we can do it
deal,
like
deal, good. I like it. Okay, so I there we go. Uh, just in starting off, let's talk about the Muskogee Creek Nation. We have now over 100,000 tribal members. That those numbers crested right after COVID. The Muskogee Creek Nation Reservation has over 3.3 million acres. We have the majority of Tulsa. We also have the majority of the city of Muskogee, Sapulpa. We have a handful of bigger areas, populated areas within the state of Oklahoma. I-40 runs through Oklahoma, the reservation, as does Highway 75. That will take you north all the way to the Omaha reservation. That was that Parker case was talked about earlier. But the Muskogee Creek Nation is also the fourth largest tribe in the United States. There are some large tribes here, so any kind of legal decision involving tribes, especially the tribes in Oklahoma, it will reverberate, and we've seen that it does. It reverberates throughout not only the state of Oklahoma and our other tribes and our neighbors here, but throughout the United States and throughout all of what we recognize as Indian country and Turtle Island. So just a little background. If I could add a little bit more, the Muskogee Creek Nation in the Attorney General's office, there were approximately 3 criminal prosecutors prior to and in the first year of McGirt. In 2019, there were less than 50 criminal cases that were filed. And as a result of McGirt, and I would say in 2024, I believe, there were maybe just under 6,000, between 5,000 and 6,000 criminal cases filed. So I believe I have 13 criminal prosecutors now. There are other attorneys as the department has also expanded. We now have, instead of attorneys, an office of attorneys who are under the Attorney General's office. We have a criminal division, a children and family division, and a civil division to be able to address all of the various matters that the tribe is affected with, as may be affected with, but also just the everyday work of reviewing contracts and matters that involve the nation and the government. We have a lot more attorneys who are handling those matters. So we're rising and growing to not only the legal landscape, the reality that we are growing in tribal members, and we consider that to be a good thing.
And if I can note here just briefly, because we put together some of these justice metrics and statistics for some of the ongoing criminal jurisdiction litigation that we're going to be talking about later, but we have comparisons to show that per capita, in terms of the number of people subject to their jurisdiction, Indians for the nation and anybody within the county for the county side, the nation has more prosecutors and more criminal judges per capita than Tulsa County has for its population. So the development of the prosecutorial, judicial, and justice capacity that the nation has expanded and undergone since McGirt is extremely, they've really extremely put resources into building that capacity in order to exercise that jurisdiction that McGirt affirmed.
And to also add into the reality of what we have, I know that for a number of years when the census would come out, Oklahoma teeters back and forth with the state of California with the number or the highest number of Indians and Native people within their state. So while that number can go back and forth, I'm pretty sure, I'm thinking Minneapolis tried to challenge us on a couple of census returns, that the city of Tulsa was the most populated in urban area with the highest number of Native peoples. So, there we have it. The top part that's not within this map of Tulsa County would also be the Cherokee Reservation, and then there's some of that also belongs over in Osage country. But the majority, when we're looking at the number of tribal members, the land area, how things are growing, there's it's a pretty hopping, busy place with a lot of things going on. One of the things we also wanted to talk about, not only with the growth with the case law that we see taking place, is the political hostility. And a lot of things that we saw taking place that didn't always make the news, or if it did, it was more of a soundbite than the reality of working these cases, exercising criminal jurisdiction, as was confirmed by the Supreme Court, and also making sure that our tribal people are safe, that they receive justice just as anyone else. Making sure that we are cognizant of the statistics. Before the McGirt decision, we recognized that Indians were experiencing victimization at a higher rate, victimization of violent crime at a higher rate than other citizens and other people of the United States. And Indian country is harder, much more difficult to prosecute these crimes, a lot of the jurisdictional complexities. But in working with this, again, the numbers going from 3 criminal prosecutors in the Attorney General's office to now 13, having jurisdictions within our newly recognized reservation. A couple of jurisdictions rented U-Haul trucks, loaded them up with every criminal file that may or may not have an Indian involved. And, and then whether or not they confirmed or knew how to confirm the status, the Indian status, it didn't really matter. The fact is that a lot of cases, boxes of files, traffic tickets to sexual assault, crimes against children, homicide, those were literally dropped on the doorstep of the Attorney General's office of the Muskogee Creek Nation. And with a lot of attitude saying, if you want it, here you go, have fun. What we realized, and a lot of, whether it's Indian country, any of our tribal reservations here, or jurisdictions in general, falling back and recognizing the importance of our cross-deputization agreements, working internally. We have everything. We have educated people. We have not only treaty rights, but we have training and laws that help us to enforce this. So we went back to our cross-deputization agreements, did a lot of training together so that if there were questions, we made ourselves available. We did a lot of teaching how to determine and factually verify who is a Native American. And I know the question came up earlier. I think we use it because it is Indian country, according to many, if not all, federal policies, as well as a lot of our treaty language referred to that. So I know for the Muskogee Creek Nation, in addressing, and then again, it's up to our citizens and our people how we choose to be addressed and how we want to name ourselves, that that there are a lot of other considerations simply by changing our name, making sure that that there's no disconnect from our historical treaties and documents that specifically name us. And the important thing is that historically tie us to who we are and our name going on. So there were a lot of things going on with on the ground with the files that were being handed over to the Muskogee Creek Nation. A lot of victims who weren't sure whether or not they were going to receive their services within the nation or with state agencies. And it also brought about that while we continued to not only implement the laws and the resources of the Muskogee Creek Nation, but also looking at a reservation status and what that now means. And I put just a handful of the things that we see that are regularly being challenged now. Our criminal law, the jurisdiction that we have understood it to be, that the Supreme Court clearly outlined it to be. Those things are challenged, and we'll talk more about that. The Indian Child Welfare Act. It wasn't long after the McGirt decision and then Castro Huerta and other case law that we saw In re SJW, where there were challenges there that are problematic. We also have it was mentioned about the Strobel case. So the issue of taxation, utilizing federal statutes that have been on the books for a long time. Suddenly they're now in question because the Muskogee Creek Nation has a reservation, as well as our hunting laws. A lot of those are recognizing rights and privileges that were recognized in treaty. But yet, at the same time, we have a governor who is challenging almost every aspect of our reservation status, of our status of Indians, our understanding of Indian country. And these were just a couple of the topics that I can pull off the top of my head, but I'm sure I hope there aren't more. I hope that we're in the presentation, you'll see how things could potentially work out. I mean, and that's what we all want are things that work out well for all of us, regardless of who you are within the state, within the reservation. But we need to get there.
And if I can just address briefly a little bit more about the governor and some of the hostility we've been seeing coming from the governor, coming through some decisions by the state Supreme Court and Court of Criminal Appeals that seem to depart pretty radically from what we've all known to be the foundations of federal Indian law, going all the way back as long as there has been a federal Indian law. As much as the story of post McGirt is one of the Creek Nation and the other Oklahoma tribal nations who've had their rights re-recognized and have rolled their sleeves up, put the work in to build their governmental capacities, build their prosecutor offices, hire more judges, hire more people on the ground, and put the work into building that government capacity. And in many cases that the AG can speak to more authoritatively than I can, building good, solid, cooperative working relationships with some of the local government entities within the reservations. We also have the story of abject hostility from a number of fronts at the state level towards the implementation of the McGirt decision. And one of the prime examples of that is in the year to year and a half after McGirt was decided. I think the number that we counted was something like 50 or 55 petitions from the state to the United States Supreme Court asking them to overturn McGirt. And we've actually seen just in the last couple of weeks in the Strobel case, the nation has Alicia Strobel, the individual Muskogee Creek citizen who filed her tax exemption petition and who got a decision from the state Supreme Court saying, "What are you talking about? The state can tax Indians in Indian country. Didn't you know that?" She has asked the Supreme Court to take that case up and clarify what we thought was already pretty plain, that within Indian country, Indians, in fact, don't have to pay state taxes. Settled law back to McClanahan, back before that. One more time, the state has filed a response in this instance with the U.S. Supreme Court saying, why don't you go ahead and overturn McGirt? Because McGirt doesn't work and it's been chaos. There's been no, the state is kind of creating a chaotic situation by not recognizing McGirt and not working in good faith to implement the law, but instead try to do everything they can to throw hurdles at that implementation and then use that, self-created confusion, harm, difficulty in implementation as an excuse for unwinding McGirt. But in that year and a half after McGirt, for those of you who don't practice before the United States Supreme Court, it might not resonate how aggressive an assault on the decision that is to file 50 petitions in a year to try to get that decision overturned. But a lot of things at the Supreme Court are still done the old-fashioned way. And when you file a petition at the Supreme Court, you have to have a very specific size little booklet that can only be printed by a couple of specialty printing shops in the nation. And you have to file, I think the number is 40 paper copies of this petition, and they have to be delivered to the gatehouse at the Supreme Court at a certain time of the day in the morning. And just there must have been a room at the Supreme Court somewhere at that time devoted to stacking up the state of Oklahoma's petitions, asking the court to undo that decision that just had been done, because that's just how paperwork at the Supreme Court works. So they were definitely making their opinion on that decision and what they think the court should do with it very well known, and they continue to make that position very well known.
It sounds like a research project I'd really like to have one of my summer interns take a look at over the history. What were the most petitioned cases or complained about cases after a Supreme Court decision?
I think we're in the running.
Okay, well, it's okay to be in first place, but there's a lot of work. So I think that if you are an Oklahoma Bar Association member, if you're in Oklahoma, it doesn't, I mean, you watch the evening news a couple of days out of the week and it doesn't take long to really see what's happening here, or social media for that matter. So not long after the McGirt decision and the establishment not only of the reservation, but the exercise of that criminal jurisdiction and authority. Some of those cases did catch the attention of not only were they appealing to the Oklahoma Court of Criminal Appeals, but as well the Supreme Court of the United States. And one case that unfortunately made it was Castro Huerta. Castro Huerta was involving the unfortunate child maltreatment case. And just saying child maltreatment does not fully recognize the brutal abuse and violence that that this poor baby, Cherokee baby, I might add, experienced at the hands of Castro Huerta. Castro Huerta was a non-native, and Oklahoma challenged that jurisdiction. The case took place in the northern part of Tulsa County, that fell within the Cherokee Nation reservation. Philip, if you want to take that from there.
Yeah, so I'm not going to go into too many details on the factual specifics and predicates of the case, but essentially the legal issue as it came up was, does the state of Oklahoma within the reservation, within Indian country, have concurrent jurisdiction over the crime of a non-Indian defendant whose crime was against a native victim? And under the old way of thinking that we all learned in law school in our federal Indian law class, the understanding was, if you have a defendant or a victim who is an Indian, then that's going to be under federal jurisdiction, that could be under tribal jurisdiction, but that's not going to fall under state jurisdiction. And the history there, way back in the early days of the reservation, federal laws were passed to create a federal framework for criminalization of crimes amongst or between Indians on the reservation. And we found out in the early part of the 20th century with the McGirt decision and the Draper decision that the court there said, you know, once you get statehood overlaid on top of a reservation, there's going to be a change there. There was no understanding of state jurisdiction for any crimes on the reservation, but actually, if you have a crime exclusively with non-Indians, non-Indian victim and non-Indian perpetrator, we're just going to go ahead and move that to the state side of the ledger. That's no longer a federal crime, and that is a state crime. And they clarified that in the 1940s, and it went all the way forward until 2022 when everybody understood just Indians, Indian victim, Indian defendant, state crime. Once you get an Indian in there as a defendant or as a victim, that's going to be a federal crime exclusive of the state. That was the understanding. It went up to the Supreme Court for Castro Huerta. The state of Oklahoma was challenging that. And the Supreme Court said, well, when did Congress specifically write down that if you have a non-Indian defendant against an Indian victim, that the state jurisdiction is preempted? They said, was that in a treaty? Is that in the Major Crimes Act? Where is that written down? And the Indian bar at that point were kind of saying, well, it's not really written down in those words per se. But if you trace the history, if you understand the development of this doctrine, if you understand how Indian country preemption works, if you understand the logic of Public Law 280, we got a bunch of stuff to hang our hat on here. They didn't really ever write it down in those words. And so we get an opinion by Justice Kavanaugh and Castro Huerta that said, you know, that's not going to be good enough for us because, as everybody knows, in Indian country, states have jurisdiction unless it's preempted under federal law. And we have to look for a source of preemption. And are we going to find preemption under traditional, don't worry about Indian country, federal law preemption principles? We don't have it here. And if you don't have that, you have to look at Indian law preemption principles, and we have a doctrine of law about that. And you've heard of Bracker, that's one way of preemption. You've heard of McClanahan, that's another way of preemption. But unless we find an affirmative source of preemption, the state is going to have the ability to exercise jurisdiction in Indian country. States have authority within their borders unless preempted. So that's where the Castro Huerta decision came down. And the number one feature of Castro Huerta that everybody should keep in mind whenever they're looking at this is that it is a decision of the state exercising jurisdiction over a non-Indian individual in Indian country. And that there's a lot of history and precedent behind that. We didn't know specifically how the court was going to rule where it's an Indian criminal defendant whose crime was. We didn't know how it was going to rule for a non-Indian criminal defendant whose crime was against an Indian. But the court has now told us when you have a non-Indian defendant, state jurisdiction is proper. That's not preempted. And that goes back to Draper, that goes back to McBratney, that is in line with all of that. We understand that states do have an interest in regulating their own non-Indian citizens within Indian country. And so that's what Castro Huerta has given us.
Interestingly enough, Castro Huerta came out in the fall of 2022. And for a lot of practitioners like myself, very unsettling in recognizing I have a Native victim who we always, if not throughout Indian country, we recognize that we have services that would be able to assist. But we have a non-native who had committed a crime against a child. In the 2013 VAWA expanded laws, the expanded criminal laws allowed the tribes to prosecute non-Indians who committed domestic violence against Native partners. So there were tests about, did you have a relationship? Were you ever in a relationship? but it did not take into consideration the reality that when a lot of these domestic violence crimes are taking place, children are either witnessing these violent crimes or they are victims themselves. So just a couple of weeks after the Supreme Court handed down the Castro Huerta decision, we also had Congress handing down the expanded VAWA crimes, which allowed tribes to prosecute if they so chose to. We could prosecute non-natives who not only commit a domestic violence crime against a partner, but if there were any crimes against children committed by a non-native, the tribes had the green light from Congress to be able to amend their criminal charges so those crimes could be encompassed. And there are a couple of additional crimes that were involved with the 2022 VAWA expansion. But that was I think it's interesting to see that you have the Supreme Court making this decision, but Congress, who had been rallied significantly to try to pull back the McGirt decision, also handed down the expanded VAWA laws, which continue to kind of chip away, if you will, chip away at the old Oliphant decision, which is now outdated as we realistically look at what's happening on the landscape of Indian country and criminal law. So there's the one hand doing one thing and one hand doing another. So therein is the interesting the dance that we have as Indian country with the branches of our federal government. So as matters were continuing to percolate, we have tribal members that we are hearing about that are being arrested and prosecuted in state court, in municipalities throughout the reservation. We were hearing about it, but it was difficult to have someone come forward to say, hey, this is going on. Therein was the case of the city of Tulsa versus Hooper. Hooper was a Choctaw tribal member who received a speeding ticket, I believe, speeding or parking. It was a municipal ticket, but he knew, as many Indian people do, he knew the McGirt decision had changed that jurisdictional landscape, and he was in Tulsa on the reservation of the Muskogee Creek Nation. So therein was the challenge. He contacted the Muskogee Creek Nation, and this was the one case that was originally brought to our attention when we were hearing about illegal prosecutions of Native people throughout our reservation. So then there was Hooper. After we were contacted, we reached out to our appellate partners, Kanji and Katzen, and we said, hey, Philip Tinker and your team, please help us. We've got some issues, and we think that this is one of those that is challenging the reservational status of the Muskogee Creek Nation.
Yeah, and so when the Hooper case started going up, the argument that City of Tulsa was relying on at that time, Castro Huerta hadn't been decided yet, and where Tulsa had been looking was all the way back to the Curtis Act, which was part of the pre-statehood Indian Territories slate of laws, which the federal government had enacted in order to turn up the pressure on the five tribes to accept allotment, enter into an allotment agreement that was seen as necessary on the U.S. side to pave the way for Oklahoma statehood. They wanted to make sure that the tribal communal land base was able to be allotted before they combined Oklahoma Territory and Indian Territory into a state of Oklahoma. The tribes were very reluctant to sign on to that. There was a decade plus period where There was a lot of back and forth. The tribes rejected offer after offer. They stuck to their guns, and Congress passed a lot of laws, one of which was the Curtis Act, which had a lot of terms and provisions in it. It terminated the tribal courts. It terminated the tribal taxing power. It had a lot of really harsh restrictions on the ability of tribes to exercise their sovereignty in a way that would be continued to be recognized by the United States. Because, of course, the United States can't take away tribal sovereignty, but they can declare on their own behalf that they're not going to recognize that tribal sovereignty. And as a practicality, that can be very impactful. So the federal government had restricted the nation's sovereignty and at the same time had passed provisions saying that the townships that existed in the Indian Territory at the time, Tulsa being one of them, the federal government authorized those townships with their own kind of government, which were not tribal governments, which were federal territorial governments, to exercise criminal jurisdiction over all people in the townships, regardless of race, I believe is the language that was used in the Curtis Act. They took Arkansas law that was in place at the time, adopted it as the law in the territories, and said the territorial municipal governments can exercise that authority over anybody in the city, regardless of race. So that was 1898 law that was on the books. And Tulsa was saying, hey, look, we're a territorial government. We were around back in 1898, and Congress gave us this power to exercise authority over all people within our territory, regardless of race. And we don't see any reason why that doesn't still obtain for us today. And it goes up to the 10th Circuit Court of Appeals, and Tulsa said, we've got the Curtis Act, we've got jurisdiction over everybody. Congress said so. We understand federal Indian law. We know unless Congress says so, we don't have jurisdiction over Indians. But unlike most places out there, Congress has said so, so we're good. And the 10th Circuit looked at that and they said, that Curtis Act is very much bound up to a certain point in history. And we can really tell, reading not between the lines, but on the lines, it's all over the text. This is something that was in place during this provisional territorial government period. And as soon as the tribes agreed to allotment agreements and we got that written up in the statutes, and when Congress passed an Oklahoma Enabling Act and did all this other stuff, the Curtis Act stuff fell by the wayside. And they looked at all of the different explicit textual provisions of those laws that made it abundantly clear that the Curtis Act is not going to be good law for those purposes anymore. It's been wiped off the books. And that's what the 10th Circuit told City of Tulsa. You don't have any Curtis Act authority. You're going to have to operate with the same federal Indian law as everybody else. And that law says you don't get to have jurisdiction over Indian defendants, tribal citizens, or non-member Indians that anybody else has. You're just going to have to deal with federal Indian law the same way every other municipality within a reservation has to do it. Now, right as the 10th Circuit had issued that decision, Castro Huerta had just come down. And so the city starts saying, Castro Huerta had all this stuff to say about presumptions of state jurisdiction exercising in Indian country, and unless you can show preemption under Bracker, unless you can show that the state jurisdiction is causing some specific infringement on tribal sovereignty, the state's presumed to have jurisdiction. Is it too late to raise that argument? City of Tulsa said in Hooper, and the district court said, yeah, it is too late to raise that argument. We've already gone up to the appellate court and back down again. There are other cases that are going on that can raise that argument, but you're too late to raise that argument. In this case, Hooper case dismissed. And so that is where the Hooper decision was left off right at the same time that Tulsa had pivoted from its Curtis Act argument to its argument that we have jurisdiction at least with respect to non-member Indians within the reservation because we read Castro Huerta to say there has to be an infringement of tribal sovereignty before there's going to be preemption of our criminal jurisdiction. And we're just going to say that when you have a non-member Indian, that doesn't interfere with the nation's sovereignty in any tangible way. And so we just have that jurisdiction there. So I'll pass it back off to the AG to talk about where that led us into these other cases that are all still pending, actually, with the federal courts.
Let me get back. Yes. Yes, and unfortunately, so the list of all the cases. One of the things I do want to point out, as opposed to, let me back up just a second. We've got Castro Huerta. Oops, I'm so sorry. Castro Huerta. I'll leave it here for the moment. We had McGirt. We had Hooper. We had Murphy. All of those being decided upon and utilizing Indian principles and treaties. One of the things that was also very interesting as standing in as the Attorney General for the Muskogee Creek Nation is all of these cases had a significant impact on the status of the Muskogee Creek Nation, our treaty rights, our inherent rights, all of these things. And so we started off by discussing how do we get these cases in our name, as opposed to trying to find the defendants, trying to find other Native people who have been wronged, and then trying to file as an amicus and kind of hope that we can work with other counsel involved to be able to have a role in these cases that significantly are basically, Indian law concerns. So we, after a lot of talk and still hearing about the ongoing illegality that was happening not only within the Muskogee Creek Nation, when we talked to our neighbors and the other reservation tribes, and not only the 5 tribes, but many of this was also happening in the northeast corner of the state of Oklahoma. We weren't alone in seeing a lot of the pushback from the counties and from the municipalities on trying to either diminish or significantly lessen the impact of the McGirt decision. So with Iski and with Ballard, both of those having significant impact on the integrity and the goings on with the Muskogee Creek Nation, we got together and filed those, recognizing ongoing illegal prosecutions of Indian people. And I say that because there were Muskogee Creek Nation citizens, as well as other federally recognized Indians who were being prosecuted. That also turned into, with the ongoing effects of that lingered beyond the 10th Circuit decision from Hooper. And Philip was talking about the pivot that the city of Tulsa did with respect to the Curtis Act being shot down by the 10th Circuit. There were still ongoing issues with the city of Tulsa, also with Tulsa County, our biggest, if not busiest, county within the reservation, as well as the city of Henrietta, who is about 10 miles south of our headquarters here in Okmulgee. The city of Henrietta blatantly arresting non-Indian people, many of those being citizens of the Muskogee Creek Nation.
Yeah, so I'll just run down really quickly some procedural posture of these 5 different cases. So these are the 5 affirmative litigations that the nation has filed against different prosecutorial entities within the reservation who have continued to prosecute either non-member Indians or all Indians within the reservation. And the first case that we filed was MCN versus City of Tulsa, and that one was just about 2 years ago today. That was in 2023, just after Hooper had come down, after the 10th Circuit told Tulsa, you don't have this jurisdiction under the Curtis Act. That's not going to fly. Go back and get it right. And Tulsa pivoted to, well, Castro Huerta has come down, and we think that that is going to give us a different basis and justification. So the nation sued City of Tulsa, and we sought a preliminary injunction. And our thinking at that time was, we're going to go ahead. We're going to get an order out of the district court. We're going to be able to take that up to the 10th Circuit, and we're going to be able to get the federal court to finish what Hooper started and just tell us once and for all, you know what the rule is for state jurisdiction over Indians in Indian country. You can't do it. It's not in the cards unless you have PL 280, unless Congress has authorized that. You're not gonna get there. So we filed the lawsuit in City of Tulsa, and a year goes by. We had our PI motion pending. We had our complaint pending. The City of Tulsa filed their motion to dismiss. That was pending, and we didn't get any action out of the court for a year. And during that year, Mayor Monroe Nichols campaigned on a platform of, amongst other things, normalizing relationships with the nation, putting the disputed litigation behind, and forging a new path going forward. And very shortly after Mayor Nichols was elected, we filed a joint motion in the City of Tulsa case asking the court to put the case on pause so that we could discuss settlement options. So we will circle, there's very little time left in our presentation, so I will just jump ahead and note we have filed in the City of Tulsa case a comprehensive settlement of those claims, and the settlement, it recognizes that the nation and only the nation have jurisdiction over prosecutions of Indian defendants, certainly the federal government as well, but the city acknowledged the city has no jurisdiction. The city will transfer all tickets, charges, other cases against Indian defendants to the nation for them to do the prosecution. And the nation and the city of Tulsa have agreed to hold a series of monthly meetings between the law enforcement apparatus of the nation and the city to talk through practical implementation issues. What do we do with the evidence? Who's got a crime lab? Can you test that, or can we do it? Our officers have a question about this and that. Who do they talk to? So there's a series of meetings that are being, conducted by the parties, and there's a promise that at the end of this series of meetings for a year, there's going to be a report and recommendation that goes to city and nation leadership about how to improve the law enforcement relationship going forward. And so that report's going to be coming out sometime in the future. We're still, in the early stages of hashing all that stuff out, but that is an example of when people decide that they'd rather work together within the boundaries of the law and try to make it work instead of look for reasons for it not to work. The kind of great cooperative advancement of tribal sovereignty and public safety for everybody that can be accomplished. Now, that's not what has happened with these other cases, unfortunately. We have the Iski and the Ballard cases, and both of these are multi-party cases where the defendants, Iski and Ballard, are the district attorneys for those districts. The plaintiffs, in addition to Creek Nation, are the Cherokee, Choctaw, and Chickasaw nations who also have reservation territory within those districts. I don't think the districts cover everybody's reservation territory, but there's enough overlap that those other of the five tribes are involved. The United States is also a co-plaintiff there. So we have tribal nations and the United States all telling these prosecutors, you know that you don't have jurisdiction over Indian defendants on the reservation. So we're still awaiting some rulings on that one. The last two cases that are pending, one against Tulsa County and one against the city of Henrietta. In these cases, we have actually just back in, I believe it was in September, we had a series of hearings on the preliminary injunction motion. So those are the first hearings we've had in any of these cases. And in the Tulsa County case, we actually got an order from Judge Frizzell in the Northern District, who was sitting on that case. And he told us ahead of the hearing, hey, if you want preliminary injunction, there's a four-part test you've got to satisfy there. And it's not just about the legal merits, it's also about the public interest and the balance of harms. And if you want me to issue an order saying Tulsa County can't prosecute any crimes by any Indians and that the nation is going to have to prosecute all those crimes, you're going to have to show me, to my satisfaction, that the nation is actually capable at a practical level of exercising that jurisdiction. Do you have the resources and capacity today? I'm not, I know you're trying. And he said he's a very candid judge. He told us quite specifically what he was interested in seeing and what his concerns were. And he said, I know there's been a big shift in criminal jurisdiction, and I know that there's been growing pains. I know that in the early days, balls have been dropped because transferring cases from the county, from the cities to the nation, it was a big influx. You didn't have all the people in place now. I'm not sure you have all the people in place who are needed for this today, so why don't you show me? And then we talked about at the beginning of this presentation some of the numbers that were developed there, where we said, yeah, in the last 5 years, the nation has hired a number of judges to put us on parity with Tulsa County for their criminal judges. We've hired a number of prosecutors to put us on parity with Tulsa County for the number of prosecutors that Tulsa County has over all of its citizens versus what the nation has for every Indian, member and non-member within the reservation. Our numbers go toe-to-toe with theirs, and we come off looking very good because the nation recognized the importance of building up that capacity and exercising its jurisdiction and have put their money and put their people where their mouth is, because they're not just talking about doing it, they're doing it. And so that's where those cases stand. We have now heard from Judge Frizzell in Tulsa County that he's not going to, in spite of all that evidence that was presented at the hearing, he hasn't been convinced that the nation has exclusive jurisdiction over non-member Indians. He said he's looking at Castro Huerta, he's looking at the Stitt and O'Brien decisions, and he believes that there is, in fact, concurrent criminal jurisdiction between the state of Oklahoma and the municipalities over non-member Indians. City of Henrietta is the other case in which we have presented that evidence and teed up for a decision from the court. And there, Magistrate Judge Robertson, who we've consented to, he's the full-time judge on the case, he has entered an order pointing in the very opposite direction. He said, I know federal Indian law. I know McGirt. I know the 10th Circuit's decision in Ute Tribe. I remember what I learned in my federal Indian law class, and I know that unless there is explicit congressional orders to the contrary, states don't have any jurisdiction over Indians in Indian country. And so he's entered an order saying, City of Henrietta, you know better. You know that you don't have this. I know that Oklahoma Court of Criminal Appeals and the Stitt and O'Brien decision, they've said you do. This is federal court. And in federal court, we're going to apply federal law. And federal law says until Congress says otherwise, there's not going to be any state jurisdiction for criminal prosecutions over Indians. And so we have those two judges in Tulsa County and City of Henrietta who are coming out on opposite sides of the spectrum on that question, which, indicates that that's going to have to go upstairs and the 10th Circuit is going to have to give us a further ruling on that one.
Yes. Thank you, Philip. And being cognizant of our time as well as, things that are going on here. Let's see. O'Brien. I say this with true disdain, in so many different ways that we are working to. We had the success of Hooper at the 10th Circuit, handed down the success with working with the city of Tulsa, working with a lot of our partners and seeing things happen. And then we had the case of O'Brien that percolated from the city of Tulsa. This case came about before or in that political season where things were being campaigned, but there hadn't been the election hadn't taken place, or maybe it had, and the new mayor had yet to be sworn in and being given an opportunity to follow through on many of the campaign promises that I know we were looking forward to. But we have Oklahoma versus O'Brien, a case from the Oklahoma Supreme Court that addressed O'Brien, who is a Muskogee Creek Nation, a non-member Indian. And then going back to this theme, I think that is within a lot of either our ICWA cases or criminal matters of the status of the non-member Indian that has been decided and is well-established law. O'Brien being a non-member Indian, the case came about so that in essence, we now have Oklahoma, not only with Castro Huerta, and it was originally understood as to be a municipal as well as a misdemeanor, only that the municipalities may criminally prosecute Indians from another tribe. Well, that really does fly in the against the grain of many of the municipal cases that we have, as well as the case law and statutory understanding of criminal law in Indian country. There's the problem of O'Brien. So I'll tee it up like that, and Philip, if you want to.
Yeah, I'm actually going to defer to Arvo really quickly to tell us if we have the time on our panel and want us to march through O'Brien and Stitt. I can do so really quickly. I'm also going to apologize and say I've just now noticed that there's a separate chat thread for the Q&A, and there are a couple of questions that were pending that I wasn't aware of. So I'm just going to really quickly note Patty Gezi, who I think probably needs no introduction here, but she was the public defender for Mr. Patrick Murphy, and he was the first case that went up before McGirt. And so one of the Oklahoma's founding mothers of the McGirt decision, and she really did incredible work keeping that issue alive and pushing it forward in the courts. She's asked in those hearings that we had on the preliminary injunction whether evidence was gathered and presented on how member and non-member tribal members are intertwined within the reservation, how they work together, work for the nations, have families in common. And the answer is absolutely. That was a major part of our presentation. As we all know, in the Duro Fix, Congress was very cognizant of those issues and how the fact that Indian people, they're not insulated just to their own tribal communities, but live together, work together, intermarry, travel, and all the social, familial, economic intertwinement is part of why traditionally there has been that criminal jurisdiction in the tribes over not only their own citizens but other citizens of other tribes. We definitely put that front and center in our presentations, and so that is part of what is in front of the courts to make those decisions. Robert Murphy has also noted that when ICWA was passed, the large amount of hostility and attempts to undermine that law, and that might be also another historical point of comparison for how the state is trying to have McGirt overturned. I don't know any numbers behind that, but absolutely, that seems like a very natural point of comparison. So,
Okay,
Arvo, let us know.
Yeah, you're welcome to. You're scheduled to go until 3:15 as it was, but I would notice that Emily has also gotten in the chat and said if you want to eat into some of her time past 3:15, you're more than welcome to. I know there's a lot going on there, so you're more than welcome to take up probably at least till 3:20 if you'd like.
well, I think we're getting close to the end. So this part of it is hitting. Well, 3:15 we should be good. Thank you. And barring any other questions and corrections. So thank you, Lou, for addressing that. And I guess in turning this around, and I think someone had either asked or had commented earlier that it is a challenge, it is a concern, and it has to be weighed when you take a case up on appeal. Especially if you're looking at the potential of the United States Supreme Court. What is the potential fallout? What are the ramifications all the way around, not only to your tribe, but to your area, the state of Oklahoma, as well as the whole of Indian country and being Turtle Island, the United States? What is the impact of that? What I am very thankful for is what Mayor Monroe Nichols campaigned on the idea that we can work together, that living in a safe neighborhood or a safe community that looks after one another, that if there is a problem, that when you call for help, when you call 911, that you're not told that you have to call another number, or that because you're Native or that you're Indian, that you have to do something else, or you're not going to be responded to, or there's a litany of other questions. And that's our reality. In many of these cases, as we're arguing Castro, Huerta, Hooper, and all of the cases that we see now from Tulsa, Henrietta, and the others, that the unfortunate basis of a lot of that is violent crime and crime taking place, and who is going to prosecute, who is going to respond. The tribal nations, without a doubt, have responded in increasing our response with either our light horse or law enforcement services, as well as prosecutorial services, the significant resources, victim services, as well as other services that are available for families for healing, and the unique aspect of healing with Indian country, as well as working through all of these. If you look at Indian country, as many of us, and I mean, there are some heavy hitters that are historic that I see on the participant list watching this. We understand and we know that Indian country is here because things have worked, things that were internal and inherent to who we are as Indian nations. Those things work. And it's by the grace of those and the creator that we are still here talking about a lot of these things. Our tribal nations weren't exterminated, whether it be the political attempts or the reality of the boarding schools and all of the other atrocities we've endured. Here we are in 2025, now facing different challenges, but challenges nonetheless. Let me check something real quick. Yep, that's our last page. But I think that there is a lot of money that goes into litigating. There is a lot of time and other resources that go into taking a case and going forward. But I'm also kind of curious, at what point, now that we have a reservation, now that we are dedicating a lot of our resources into things that we had before, if we see flagrant violations of those laws that we understand are contrary to the way things work, at what point do we say that that's enough? And I challenge you on that, because that's not how it's supposed to be. I wish that we were using a lot more of our resources toward either economic development or parks, beautification, different things that not only enhance and improve the lives of our Muskogee people, but of all Indian people, as well as everyone else that is living and residing within the reservation of the Muskogee Creek Nation. So that's the hope. Even though in this picture you'll notice the Indians are the ones who are not smiling, but we're smiling inside in our hearts, and it's the mayor and his the public safety commissioner who. They have nice smiles, but this was something that was well fought for. A lot of work continues to go into the settlement. It's like a marriage, and we have to be our own marriage counselors. We have to check in regularly. What's working? What's not working? What needs attention? What needs fixing? And it may be something new, and it may look vastly different from the north and the southern parts of your reservation. After an election cycle, it may look different. What doesn't look different, I believe, is the dedication of the nation to all of these things, and also the impact that we recognize that comes along with these growths, these challenges. The Muskogee Creek Nation has been referred to as the tip of the spear, in recognizing that there are a lot of challenges. And on the other side of that V, it's either the Muskogee Creek Nation or one of our citizens, or an issue that arose within our reservation. We want to make sure that people are safe, but also follow the law. Philip, if you have any other closing comments.
Well, I don't really have any closing comments. We do have a couple of questions that popped up. I'm going to give one to you, and then I'm going to take a stab at the other one. If anybody else has questions, go ahead and get them in now. We'll try to answer them, but we also want to, segue into the rest of the presentation. So, Zach Waldrop, AG, has asked what resources exist for state and municipal entities to identify the Indian status of a criminal defendant? Is it all voluntary disclosure on the part of the defendant, or is there anything proactive that they can be doing, and what does that look like?
Let me ask. I'll ask kind of some follow up. Proactive on part of whom? Are we talking about the municipality, or the tribe, or the individual, or something else?
My understanding is at the city, the municipal, the county side, what are they supposed to do? How are they supposed to know?
And this goes to a lot of the training that we have with our with law enforcement and first responders, is simply asking, are you native? It takes about less than 2 seconds. Are you native? And however they respond, if they are native, yes, I am Cherokee, I'm Muskogee Creek, I'm Blackfeet, whatever the case may be, fine. The officers write it down. Once it comes into my office, that's where we will go through the efforts of doing the verification that, in fact, they are members of a federally recognized tribe and not descendants or someone talking about their Cherokee great grandmother who was a princess. And I do want to point out, our email information is here. If you do have some questions that are not answered, please feel free to reach out, and I would love to hear from you and be able to help however I may.
Okay, so I'm going to try to touch on Patty's question really quickly. She's saying, and we didn't get a chance to talk about the state Supreme Court Strobel decision in any amount of detail, but Strobel decided that, yeah, the state can tax a Muskogee citizen who works on the reservation for the Muskogee Nation, lives within her reservation. Who's ever said the state can't tax that? And we said, McClanahan said that. McClanahan said that the state can't tax that. Patty's asking, if the Supreme Court denies cert, what would the next steps be to challenge that? And if they grant cert, do we think that the Supreme Court is going to affirm the law as it always has been? And I think really at this point, what we're able to say is that the state Supreme Court's decision is sort of the very definition of lawlessness. We have, and I'm going to probably get the numbers wrong, but we have maybe it was six justices on the state Supreme Court who wrote six different opinions trying to justify their holding in that case that states have jurisdiction to tax tribal citizens on the reservation. Basically, none of them signed on to each other's opinion. There wasn't anything approaching any sort of a consensus on a legal justification for that holding. So they knew where they wanted to go. They really don't have any kind of concrete legal analysis that points the way to getting there. So we do. The case has been presented. Both Ms. Strobel and the Nation, which filed its own brief as an amicus in support of Ms. Strobel, feel very confident that we know what the law is, and this is as outrageous a rejection of the idea of applying the law as one is likely to find from a state court. And so we've taken it to the U.S. Supreme Court, and we're going to give them the opportunity to affirm the law that has really never been subject to any kind of meaningful challenge at the U.S. Supreme Court since McClanahan, which is within the reservation, tribal citizens of their own tribe within their own reservation are not subject to state tax. You're not going to find anything in Supreme Court precedent to point in the other direction. And so we're just going to give the court the opportunity to apply its own law as it always has been.
If I may add to that, I think that if it doesn't get granted cert, I hope that that's not any grounds for the governor to back down on his multiple comments that he has made that he's going to just simply remove the personal income tax for the state of Oklahoma. So let's see that happen. But just a follow-up note on that. So are we good on our questions? And again, if there are any posed, and if you don't, if you haven't put one into the chat, then please feel free to reach out to us. And I think it just updated Philip Tinker. I think I wrote on his name Tinkler. I apologize, Philip Tinker. But the emails are correct. If you would like to reach out to us.
All right. A lot of good questions, a lot of good discussion there. Just a couple things, as lawyers, it seems very strange to see this Duro type argument kind of, come back to life. You thought it had been buried, I don't know how long ago, it's like at least 15, 20 years ago, but then it suddenly springs up again. It's very strange. And so it's like we're trying to go back and relitigate things that obviously were taken care of by Congress with the quote unquote Duro fix. And as lawyers, this is just an observation. I think it's important for us, and I think more and more Native people, and this kind of goes back to the term Indian, Native American. I think more and more people, and I did this specifically in our agenda, is to refer to ourselves as citizens of nations, citizens, not just we have some blood, because this is one thing that in doing training to law enforcement that I've used, and it's really turned on a light bulb for some of these law enforcement officers. I'll say, well, is there anybody who's Italian or Irish or German in the crowd? And hands will go up and say, okay, but are you a German citizen just because you have some blood? Are you an Irish citizen? Can you exercise political rights? Are you entitled to benefits that a citizen of those countries has just because you have the blood? And that's really what we're talking about, And in terms of trying to determine is somebody Native or not in terms of their citizenship, we have that happen in investigations all the time. If we have an offense that takes place on Tinker Air Force Base or Fort Sill, we have to determine if that person is military or not. Because if they're not military, then the civilian authorities have jurisdiction over them. And it's not like, well, you have to look to, well, hey, you don't look military to you, and we fall into this trap, and it's been reinforced, unfortunately, by some either deliberately or unknowingly, where it becomes, this is a racial thing. So somebody's race is determining who has jurisdiction. And again, that's not what it is. You're a citizen of a nation. And sometimes race is part of the equation. But, those of you that, if you're from full-blood Indian from a tribe that's been terminated, you're not Indian legally. If you have some blood of some sort and you're not an enrolled citizen of a tribe, then you're not a citizen of that tribe. And I think it's really important as lawyers that we start talking about this concept of citizenship as opposed to so-and-so has this much blood and they're automatically, they're automatically an Indian. The same goes true for the freedmen. There have been Seminole freedmen who have been citizens of the Seminole Nation for a long time. Technically, are they Indian? No, they're not. They don't have the Indian blood because that's what the federal law says. So trying to figure out jurisdiction based upon someone's quote unquote status is not something new. It's not something unusual. Just like illegal aliens. I mean, you can't look at somebody and say, well, I think you're an illegal alien, or I think you are. And do we rely upon just what they say? Well, of course not. We have to go and check the enrollment records, check their, fingerprints, because a lot of times they'll give different names. But I think that's important for lawyers, that we reinforce this concept of citizenship. Well, thank you again, both, for just a very good discussion. And for those of you that haven't gone to the Dropbox, a lot of these opinions and briefs are in the Dropbox if you want to read them. Especially the city of Henrietta opinion is very well reasoned. And it goes to, again, the education that lawyers have when they go through law school, whether it's Tulsa or OCU or Oklahoma, and you have an Indian law course and you learn this, then you generally get the right result, as opposed to, well, I just don't know what this is, and it's very foreign to me, and I'm just going to kind of make decisions maybe not based upon the law or statutes. Okay, we're going to turn it over. Our next speaker, and again, thank you, Jerry and Philip, for your presentation, is going to get started. Before we do that, I want to give you the next code word. And of course, those of you who don't know, the very first treaty that was entered into by an Indian nation with the United States was in 1787, and that was with the Delaware. So our third word is Delaware. Again, we had Quapaw, Oneida, and Delaware. Our next speaker is Emily. I've practiced this. Emily Efterakis. She's the executive director of the Tribal Sovereignty Institute at the Oklahoma City University School of Law. The Institute is a platform created to promote, celebrate, and educate on issues surrounding the tribal sovereignty and legal issues faced by the 39 tribal communities in Oklahoma. She's also an instructor of law at OCU Law School, and has been teaching with the American Indian Wills Clinic, the Indian Civil Rights Act, and other Indian law courses. She's also of counsel in the law firm of Kroll, Corky, Meyer, and Bahena, and she's a citizen of the Cherokee Nation and the Delaware tribe, not the Western Delaware. I think it's the other Delaware tribe here in Oklahoma. So I'm going to turn it over to Emily.
Okay, I'm going to share my PowerPoint. So if you will just give me a thumbs up and let me know that it's coming through. Okay,
that's good.
Perfect. I am technologically not advanced, so I'm proud of myself for doing this. Well, thank you all so much, and thank you to Arvo for having me here today to give you what I hope to be a very brief Indian law case update. Thank you to my fellow presenters. Bob, that was a great presentation, and Philip and Attorney General Weisner, that was really informative. And I had a few of your cases on my slide deck that I think I can skip over now, because you all did a really great job of presenting those, and obviously have a lot more insight into what's going on in those litigations. So this slide deck, I will tell you, is inclusive of a lot of different opinions and actions that have come out of courts from the U.S. Supreme Court, 10th Circuit, the federal district courts here in Oklahoma, state courts. I'm not going to spend time today talking about every single one of those litigations, the things that are happening, but they are here just for reference. If there's anything specific that you see that relates to your practice area that we did not talk about, feel free to reach out to me. I've tried to provide the case numbers so that you should be able to pull those decisions and those opinions. But if not, I'm happy to help direct you to where you need to go if there's something specific that we did not talk about that you would like some more information about. So we'll start first with the United States Supreme Court. There haven't been any specific decisions this year affecting Indian law or tribal communities to the degree that we've seen these cases come out of the U.S. Supreme Court in the past, such as McGirt and Castro Puerta. We've got, as Philip and A.G. Weisner already mentioned, a petition for cert that's been filed in the Strobel case. So far, we've got the petition, several amicus briefs, as well as the state of Oklahoma, who has filed their brief in opposition as of December the 5th. So that we are waiting to see what the U.S. Supreme Court does in that particular case. We've had several petitions for cert that have been denied. Again, they're listed here. Stitt versus City of Tulsa is here. I again believe that maybe Philip had touched on that as well. That's a state criminal jurisdiction in Indian country case. These other cases I've got listed here for denial of cert petitions. One petition for rehearing that has been denied is the Apache Stronghold versus United States case. And I mention this case because it's unique to me because there was a dissent to the decision to deny the petition for cert earlier this year by Justice Gorsuch. This case is, the underlying case, seeks to protect Oak Flat, which is a sacred Apache site in Arizona, from a large-scale mining project. In May of this year, the Supreme Court declined to hear the petition for cert filed by the tribe. We have Justice Gorsuch, who issued a 17-page dissent against that decision to deny the petition for cert. In that dissent, he argued that his fellow justices had made a grave mistake by refusing to hear the dispute. He said the case raises significant matters of law that deserve to be resolved before the federal government turns Oak Flat over to foreign mining interests. Based on that, the tribe then went and petitioned for rehearing, which the court also denied, this time without any kind of written dissent from Gorsuch himself. We have other notable Supreme Court filings that have potential implications for Indian law, nothing on Indian law specifically, but cannabis use, gun ownership, voting rights challenges, as we're all aware, have potential implications for those who are practicing in Indian country, depending on what the court decides to do. Moving on to the 10th Circuit, the first opinion I want to spend some time on is the 10th Circuit's opinion in the United States versus Hobson. And that case site, the case number is there if you want to pull any of the briefing in this case. So the background, this case deals with a Major Crimes Act prosecution for felony assault occurring on the Muskogee Nation Reservation by an Indian and against an Indian victim. At trial in this case, the district court instructed the jury on the lesser included offense of misdemeanor assault. This was actually a request made by the defendant Hobson's co-defendant. In this case, our defendant here in this case did not object. Ultimately, Hobson was acquitted on the felony assault that he was charged with, but convicted on the lesser included misdemeanor assault. So the question is, can the court, does the district court in this case have jurisdiction to convict on a lesser included offense? So this opinion is broken down into several parts. Initially, the court goes through and does a subject matter jurisdiction analysis. When they're looking at subject matter jurisdiction, the court reminds us that our baseline rule is that district courts may not exercise jurisdiction absent a statutory basis. I think we're all well aware of how we get subject matter jurisdiction in federal court when we're dealing with Indian defendants. Here in this case, the statutory basis is 18 U.S.C. 3231. Specifically, for district courts to have subject matter jurisdiction over offenses under this case, under the statute, Congress must have made that offense a federal crime. When we're then narrowing down subject matter jurisdiction over Indian defendants, the court acknowledges that there must be a clear expression of the intention of Congress before state or federal government can prosecute Indians on Indian land. So the court then turns to a plain text analysis of the relevant federal statute at issue here. First, they look at the General Crimes Act, which specifically carves out cases involving Indian on Indian offenses committed in Indian country. The court says that those offenses are reserved to the tribes unless they are listed in the Major Crimes Act. When we look at the Major Crimes Act, we see the list of crimes. We see that felony assault, the charged crime in this case, is specifically listed. The court also looked at 18 U.S.C. 3242, which is a procedural statute that entitles Indian defendants prosecuted for crimes under the Major Crimes Act to be entitled to the same procedural rights as any other non-Indian defendants. So this is our baseline. This is our background. These are the statutes that apply, and these are the rules of law that the court is using to determine whether or not there is jurisdiction for the district court to convict on this lesser included offense. So backing out, the court made some undisputed findings of law. They found that number one, the district court did have subject matter jurisdiction over the charged offense, the felony assault under the Major Crimes Act. Felony assault includes the crime of misdemeanor assault. The court said the government could not have indicted Hobson under the Major Crimes Act for misdemeanor assault because it's not listed. Going back to our definition, we can look and see here, we don't have any kind of language that includes a simple misdemeanor assault, just felony assault. The court found that the jury was lawfully instructed on the lesser included offense, and the court found that the jury acquitted on the felony assault that was charged, but convicted on the simple offense. So again, did the court have jurisdiction to convict? The 10th Circuit said, based on the plain language of the federal statutes, there is no jurisdiction to convict and sentence for simple assault. Going back to that very first statute, section 3231, the statutory grant of subject matter jurisdiction, the court said offenses against the laws of the United States are only those listed in the Major Crimes Act. The Major Crimes Act specifically lists felony assault as a federal crime, but the statute does not include the misdemeanor assault, the lesser included offense. The court said that there's no conflict with section 3242, which provides all procedural avenues for Indian defendants. That misdemeanor simple assault committed by an Indian against another Indian in Indian country is simply not a violation of federal law under either the Major Crimes Act or section 3242. So at the end of the day, only a tribal court can prosecute for the crime of simple assault under these circumstances. The government made several contrary arguments. Number one, they argued that the court should just imply that all lesser included offense are within the district court's jurisdiction. But the 10th Circuit said if it's not specifically listed in the Major Crimes Act, the district court has no subject matter jurisdiction. And they gave the example of murder, manslaughter. So again, if we go back to the Major Crimes Act text, we see the listed offenses, murder, manslaughter. Manslaughter is the lesser included offense for murder, and both are listed in the Major Crimes Act. So in that scenario, if you have an Indian defendant who is charged with murder and the lesser included offense of manslaughter is provided, the instructions provided to the jury, and the jury convicts, then the court does have subject matter jurisdiction to ultimately convict and sentence that Indian defendants. So again, this is a very textualist approach to interpreting these statutes and applying them to Indian defendants. The government also argued that section 3242 is a jurisdictional statute authorizing lesser included offenses not listed in the Major Crimes Act, but the court says no, this is procedural only. 3242 might entitle a defendant to an instruction, but it does not vest jurisdiction. Otherwise, that's not already provided. The government also looked at and argued that the decision by the U.S. Supreme Court in Keeble versus U.S. requires a different result. In that case, we had an Indian defendant charged with felony assault under the Major Crimes Act. That defendant requested the lesser included offense instruction, but the district court refused to give it. What that decision says in Keeble versus U.S. is that an Indian defendant charged under the Major Crimes Act is entitled to receive the lesser included offense instruction regardless of whether the offense is listed in the Major Crimes Act or not. Again, they're entitled to the instruction, but the court doesn't have jurisdiction to actually convict unless the lesser included offense is listed in the Major Crimes Act. So this case is interesting for a couple of reasons. Number one, the 10th Circuit declined to join the 8th, 5th, 9th, and 4th circuits that have come to different conclusions. Those courts have determined that this is not the correct line of reasoning, that lesser included offenses, even if not listed in the Major Crimes Act under an implication theory or another one of these theories that the government has argued, the defendant can be convicted. The court does have subject matter jurisdiction to convict and sentence in those scenarios. Another thing that's interesting about this case is it sets up what could potentially be an interesting strategy for criminal defense attorneys representing tribal clients with Major Crimes Act charges. Do you, for example, if your client is charged with a crime and the lesser included offense is not listed in the Major Crimes Act, would it be strategically beneficial to your client to request that lesser included instruction so that the jury potentially, if they don't want to convict on the higher crime, they potentially can select that lesser included offense and potentially then get your client absolved of the charges because, again, the court does not have jurisdiction to ultimately make that conviction. So there were a couple of questions earlier about citizenship and how do we go about proving Indian status in federal court or perhaps in tribal court. The case of United States versus Hatley, we get a decision from the 10th Circuit that they have not opined on the specific question in the past. They have dabbled around but never definitively answered the question of whether or not the government must prove a defendant's Indian status at the time of the offense. So in this particular case, the offense at issue is involuntary manslaughter, a car accident that occurred in February of 2017. There was a charge under the Major Crimes Act. At trial, the government offered various pieces of evidence to prove the defendant's Indian status. Things like a July 2020 document filed in state court where the defendant had stated he was a citizen of the Cherokee Nation, an unsigned tribal verification letter, testimony by the Cherokee Nation tribal registrar, and the defendant's own testimony that he was a citizen of the Cherokee Nation. However, during that testimony, the government did not elicit any information about the date of the enrollment, and they didn't ask him whether he was a tribal citizen on the day of the actual accident in question. So I think we're all aware, we all know what proof of Indian status for criminal cases requires. It's a two-part test. Number one, the defendant is going to have some degree of Indian blood. And number two, they must be recognized as an Indian by a tribe or the federal government. So again, does the government have to prove the defendant is an Indian at the time of the offense for charges under the Major Crimes Act? The 10th Circuit, having not answered this question before, gives us an answer now, which is yes. We must prove that the defendant is an Indian, was an Indian at the time of the actual offense. And they go about giving us some information on how to go about doing that. Number one, they say a CDIB card, that certificate of degree of Indian blood, which is self-authenticating. If the government can produce that, that is going to show that the defendant is an Indian for purposes of prosecutions under the Major Crimes Act. The court said that the tribal verification like that introduced here is not self-authenticating and potentially could be inadmissible hearsay unless falling within a specific hearsay exception. So again, when we're talking about proving Indian status, we're not looking at prior to an accident. We're not looking at after an accident. We're looking at the time of the actual charged incident. Is the defendant an Indian for purposes of bringing them into federal court? And in another opinion that was released by the 10th Circuit, it's not noted in your slides, but I'll give you the case citation. It's United States versus Hebert. That is case number 24-7030. This kind of is the counter to the Hatley case we just discussed, which is the government's requirement to prove that a defendant is non-Indian beyond a reasonable doubt. So in this particular case, we've got a charge of aggravated sexual abuse in Indian country and against an Indian victim. But the government in this case charged the defendant under the General Crimes Act, not the Major Crimes Act. Because of that, the court said that the government was required to prove that the defendant was non-Indian beyond a reasonable doubt in order for the prosecution to move forward. Same test laid out in Hatley. To prove Indian status, we've got to show some blood quantum and some recognition by the tribe as an Indian. Here, to prove non-Indian status, the prosecution was required to prove the defendant had no Indian blood or that neither the tribe or federal government recognizes him as an Indian. Prosecution failed to do so. They offered testimony, but the court said that wasn't enough. There was no DNA or genealogical evidence to show that the defendant had no Indian ancestry. Ultimately, the conviction was reversed because the government was unable to prove beyond a reasonable doubt that their defendant in this case was a non-Indian. Oklahoma District Court. So we've got a lot of cases that are coming out of all of the federal district courts here in Oklahoma. Again, I've got brief descriptions of each of those cases here in the slides. I'm not going to spend a lot of time going through each and every one of them. You're welcome to take a look. I will point out that United States versus Christie, that's out of the Northern District. This is more a procedural decision for those of you that are working in prosecution roles with the federal government. In this case, the court said that the government can obtain a pretrial determination as a matter of law that the location of a charged crime is in Indian country. In this case, the government sought a pretrial determination that the crime charged was committed in Indian country for purposes of the Major Crimes Act jurisdiction. As evidence, what the government used in this case were images and a link to a map of the Muskogee Nation Reservation to prove the location of the charged crime is within Indian country. The court said, okay, we'll go ahead and enter that pretrial determination. We'll find as a matter of law that the location of the charged crime is in Indian country. However, only the jury gets to determine whether the alleged crime occurred at that specific location. So again, you're able to dispose of these pretrial matters, whether by stipulation or by court determination, whether or not the charged crime happened in Indian country. So again, the Muskogee Nation versus Coonsweiler or Tulsa County, Phillip and Attorney General Wisner already went through this opinion, went through this case. I'm not going to, again, spend a lot of time because we don't have a ton of time to get into the specifics. I have some information about the specific nation's arguments, the court order, and as Phillip mentioned, this decision is the polar opposite of the decision that came out of the Muskogee Creek Nation versus Henrietta case. So this information is here to the extent that you want to take a look at the specific arguments and what the court ultimately ruled. The reasoning, as Phillip and Attorney General Wisner mentioned, is a bit curious. They default to the preemption analysis from Castro Huerta, find that there's no federal law that preempts state jurisdiction here in this case. They look at the preemption by unlawful infringement on tribal self-government and ultimately go through a policy analysis, as Phillip had mentioned, asking a lot of questions about the city of Tulsa being a large metropolitan city and the Muskogee Nation. Can they properly prosecute and handle the number of cases that would result if it was correct in its argument? The court ultimately decided against the abundance of evidence that Phillip mentioned was offered and declined to enter a temporary injunction in this case. I want to move to, briefly, I don't think I have Henrietta cited in the slide deck, but I do just because we talked about the Tulsa County case. I want to talk a little bit about the Muskogee Nation versus Henrietta, because this opinion, which was released on November the 18th, again, like we've said, is the polar opposite of the Northern District's opinion in the Tulsa County case. And I think Arvo's mentioned this. I think Phillips mentioned this. I think A.G. Wisner has mentioned this. There is some very powerful language in the Eastern District's opinion that was released, powerful language supporting tribal sovereignty, the Supreme Court precedent acknowledging the arguments that were laid out in McGirt, the findings in Castro Huerta. There's also a really strong policy argument where the court says, contrary to the Northern District's decision that allowed policy to weigh strongly in favor of denial, in this case, the Eastern District says that public safety is not imperiled by fidelity to the law. When governments invoke fear to defend power, the court's duty is to separate the echo from the evidence. Here, only the echo remains. Budgetary consequences do not expand jurisdiction. The Constitution does not bend to convenience. Sovereignty is the measure of a nation's dignity and a republic's word. A covenant still standing between law and land, written first in promise, and now reaffirmed in precedent. The Creek Nation endures, and so too does the nation's right to govern its own. Again, some really powerful language in the Henrietta case that acknowledges the Creek Nation's right, the right to prosecute non-member and member Indians, regardless of what the state of Oklahoma believes their rights are in that same context. Another case that's come out of the Eastern District that I think has some interesting implications moving forward for civil practitioners is the Barrick versus Board of County Commissioners of McGirt County case. This is a 1983 action that was filed after sheriff's officers who were cross-commissioned with the Choctaw Nation engaged in a struggle between the plaintiff here, Barrick, who was ultimately hospitalized after that struggle and later died. Barrick's personal representative filed a 1983 action. A 1983 action is unavailable for persons alleging deprivation of constitutional rights under color of tribal law. So the question here is, were the officers in this case, cross-commissioned officers with the Choctaw Nation, acting under color of state law or under tribal authority? Well, how can we tell? The court gives some guidance in looking at whether or not cross-commissioned officers are acting under tribal law or state law. Number one, when carrying out an arrest in Indian country, officers act under color of tribal law by virtue of these cross-deputization agreements. A state law enforcement officer has no jurisdiction to arrest an Indian in Indian country. So it doesn't matter what uniform they're wearing, what car they drove, or how they were dispatched. Doesn't matter whether they came from the county, whether their uniforms say county. If they are cross-commissioned, the only thing that matters is the defendant's Indian status, the location in Indian country, and the cross-deputization of the defendant officers. So in this case, the court dismissed on a motion to dismiss by the county this 1983 action, saying that there is not a 1983 action available for any kind of claim of violation of constitutional rights when the cross-commissioned officers are acting under color of tribal law. So a similar decision to that in Walden versus City of Duncan. This was decided 7 days prior to the Barrick decision in the Western District. Same issue. Can an Indian defendant bring a 1983 action against a cross-commissioned law enforcement officer for actions occurring during an arrest in Indian country? In this case, our defendant was an Indian arrested in the City of Duncan, which is within the Chickasaw Nation Reservation. The law enforcement officer held a Chickasaw Light Horse Special Law Enforcement Commission at the time of the arrest. The court said the whole ballgame on this question comes down to whether the officer who was wearing a Duncan Police Department uniform, driving a Duncan Police Department cruiser, responding to a dispatch from the Duncan Police Department, was acting under color of state or tribal law when he arrested the plaintiff, Walden. The plaintiff was taken to the Stevens County Jail, charged with state law crimes and with crimes under the Chickasaw Nation Tribal Code. The court in this case said the plaintiff is jurisdictionally barred from recovering under Section 1983. He was also barred from any action brought under the Oklahoma Governmental Tort Claims Act for similar reasons. So again, practitioners practicing in civil rights for deprivation of constitutional rights by cross-commissioned officers, if you've got an Indian client, you do not have a 1983 claim in federal court. I've got other notable federal district court filings and opinions noted. Again, I'm not going to spend a lot of time talking about these. The Wichita and affiliated tribes versus Burgum is a claim related to the federal Indian boarding school program. So this is, I think, one of the first of its kind. So it'll be an interesting case to watch. Cheyenne and Arapaho tribes are also suing the Secretary of the Interior for funding cuts to the Bureau of Indian Education. Again, another interesting case to keep an eye on. Oklahoma State Court opinions. Again, I'm going to kind of speed through these here a little bit. We've got Cherokee Nation versus Department of the Interior. Again, we've talked a little bit about the I diplomatically say disconnect between the state administration and the working with the tribes. Here in this particular case, the Attorney General was attempting to assume control over some state litigation where the governor is named a defendant, and the federal district court certified a question to the Oklahoma Supreme Court, who in turn said the Attorney General unfortunately does not have that authority. We also have a decision in a guardianship case that defines the definition of Indian country for purposes of the Indian Child Welfare Act. In that case, we have a private guardianship, a petition for appointment of guardian that was filed in Rogers County. Cherokee Nation intervened in that case. After some time, the Cherokee Nation decided that they wanted that case transferred to Cherokee Nation Tribal Court. That was post McGirt, and post the court findings of the Cherokee Nation was never disestablished. So the Cherokee Nation decided they wanted to intervene and take over the jurisdiction of this case. The Oklahoma Supreme Court ultimately decided that based on U.S. Supreme Court precedent that recognized the continued existence of the Cherokee Nation and the definition of Indian country found in the Major Crimes Act does apply to the Indian Child Welfare Act based on ICWA's definition of reservation, which specifically refers to Section 1151. The court was very particular that this holding is applied and limited to ICWA cases only, likely because the Strobel decision was released fairly soon thereafter. Again, Philip and Attorney General Weisner have already discussed the Strobel decision. I'm not going to spend a lot of time on it. But again, we are watching and waiting to see what the U.S. Supreme Court does with that case. A couple of other cases to note, Bertrand versus State. This case tells us that in order to qualify to prove Indian status, we have to prove that the defendant for criminal purposes is a member of a federally recognized tribe. So any kind of connection to a non-federally recognized tribe is not going to be enough to qualify a defendant as an Indian for criminal jurisdiction purposes, thus giving the state jurisdiction to prosecute these cases. Tribal court opinions, I will jump over that. Federal legislative updates, these are here for you to take a look at. Nothing major to note. Executive orders, I think we've all sort of followed the executive orders coming out of this White House that are affecting, whether legally or not, tribes and the classification of being an Indian as a racial group. Regulatory updates. One, I will point out there was an update to the ICWA regulations that authorize federally recognized tribes to designate agents for purposes of notice for ICWA. And just to sort of go back on some current issues for the last few minutes, these cross-deputization agreements, the orders that we've gotten from the Eastern District and the Western District on the issue of 1983 claims against cross-commissioned law enforcement offers. Again, because these courts have determined that Section 1983 claims are not allowed to be brought against government officials acting under tribal authority, these decisions ultimately limit the civil rights of tribal citizens in most of Eastern Oklahoma. What the ultimate effect of these decisions could be is an unintended incentive to cities and state agencies to cross-deputize their officers with tribal governments to shield themselves from potential 1983 liability in federal court, and thereby transferring and tracking that over to the tribes to have to deal with. It also means that Indians in nearly half of Oklahoma lack the ability to challenge a deprivation of their civil rights when encountering city, county, or state police in public or in jail. The Walden case, that's the Western District case, that has already been appealed. So we may get a decision from the 10th Circuit weighing in on this issue. Lingering questions. What about freedmen? Generally, to qualify as an Indian, I think we mentioned this earlier, to qualify an Indian under federal law for criminal jurisdiction purposes, there must be some degree of Indian blood. Freedmen are typically granted tribal citizenship based on descendancy from former slaves. Tribal citizens without an Indian blood quantum are not considered Indian for criminal purposes. So for 1983 cases, which are civil cases, and being an Indian for civil purposes doesn't carry the blood quantum requirement, there remains this open question whether or not tribally cross-commissioned state officers are going to have any authority when dealing with freedmen or citizens that lack an Indian blood quantum in Indian country. Likewise, we've got questions about whether tribal light officers that are cross-commissioned by state entities can be sued under Section 1983. So again, the flip side, if we have tribal officers who are cross-commissioned and thereby operating under color of state law, are they then subject to 1983 actions by non-tribal citizens? We've talked about the Muskogee Creek Nation settlement agreement with the city of Tulsa. I again applaud the nation and the city of Tulsa for setting an example of what it looks like to work together, government to government. And finally, I will touch very briefly on something I'm sure we've all seen, the tribal conflict with the Oklahoma Department of Wildlife. Again, the state has come out and in a press release said that they will be enforcing state wildlife laws regardless of tribal citizenship. They will start ticketing, and they have in fact begun ticketing. They have filed several cases in state court. The Attorney General has entered an appearance and dismissed those cases. Since then, the governor has appointed a special prosecutor to pursue those wildlife crimes involving tribal citizens. That special prosecutor has been refiling the cases the Attorney General has dismissed. And on November 18th, the Chickasaw, Choctaw, and Cherokee Nations filed suit in the Northern District, alleging that the governor and state officials are unlawfully prosecuting tribal citizens for hunting and fishing on tribal land. So that will be one for us to watch as we move into the next year as well. And I think there are some questions, but I don't know. Oh, here we go. I hear a chat going off. So Linda Epperly, thank you. She says, you are seeking permission to seek in-bank review in Hebert, all other circuits to consider the issue of proving non-Indian status, make that an affirmative defense. So the government would have some idea of the citizenship the government must disprove. We don't want to quiz all federally recognized tribes to disprove membership and have found disproving Indian blood to be difficult, especially where defendant has few relatives or was adopted. Thank you. That's very helpful. And that's a really good piece of information to know. We will keep an eye on that and see what the court decides to do. I think I am a couple of minutes over, and that is all that I have. I apologize for the brevity of that presentation, but if there are other questions or you have any kind of question, concern that you would like to get in touch with me, please feel free to do so. I believe my bio and information is included in the materials in the Dropbox. Thank you so much.
All right. We really appreciate that very, very good summary. Again, those materials are in the Dropbox, so I would encourage those of you that want to look up those cases. And this is really the nuts and bolts of prosecution now and considering civil rights issues, making sure that the law enforcement has the proper authority and figuring out which authority they're able to exercise whenever they're carrying out their duties. All right, because we need to have a full 50 minutes for our next session on ethics, I want to go ahead and get started with that. Our next word, which is going to be the second to the last word, is a reference to a tribe that was located in Oklahoma over what ultimately became the Tonkawa Reservation just for a few years in the late I think it was in the 1880s. And that tribe is Nez Perce. Nez Perce. Of course, the Nez Perce were Chief Joseph's people, and they ultimately were able to return to their traditional tribal homelands in Idaho, but they were in Oklahoma for a short period of time, much to their detriment. All right, our next speaker and final speaker is our Vice President, OIBA Vice President Stephanie Hudson. She's a member of the Kiowa tribe. She's a descendant of Chief Lone Wolf and also Monkey, known as Kiowa Bill. She is presently the Executive Director of the Oklahoma Indian Legal Services and is a clinical professor of the American Indian Estates Clinic. Before becoming the Executive Director at OIL, Stephanie was a staff attorney for 15 years and provided legal assistance to tribal members in Oklahoma tribal courts as well as state courts in Oklahoma. For OIL, she also worked with the Oklahoma Supreme Court's alternative dispute resolution system. She has her Juris Doctor from OCU Law School and an accounting degree as well. I didn't know that. She's a member of the Board of Directors of the United Urban Indian Council and has served on the Board of Directors of the Jacobson House. And I remember last year you were, I believe it was named as the Outstanding Indian Parent of the Year by the National Indian Education Association, correct? I think you need to turn your mic.
I thought I unmuted myself. Yes, I was. My son
Yes.
Jackson might be like, what? No, he's a good kid.
All right. Well, we're going to go ahead and turn it over to Stephanie again. That fourth word is Nez Perce. There's going to be one more, so you have to stay all the way to the bitter end to get the fifth word. And I'll turn it over to Stephanie.
I missed the third word. I'm going to have to
Uh-oh.
get it from you later. Or I was listening, I swear, when you said the third word, it was
Okay.
about Philip and
Delaware.
Delaware. Thank you. Okay. So I have prepared a presentation on cultural competence as a ethical obligation. OIL's attorneys, we practice a lot in tribal courts, and we were, as Professor Miller was very surprised about what happened with the McGirt decision. The OIL's attorneys, we were also very surprised. We were cheering in the office and everything, and we had people crying because, at the end of the Trail of Tears, as soon as we read that, we're like, oh my gosh, can you believe this? So we've had an influx of attorneys practicing in tribal courts, and OIL's attorneys, we've seen a lot in tribal courts about how attorneys practice, and we've talked to a lot of tribal judges about what they've seen in tribal courts with attorneys. And probably one of the primary things that we see is just attorneys understanding the culture that their client is coming from, and of course communication. The OBA always says that number one complaint from clients is my attorney's not calling me back. So we're going to talk a little bit about communicating with tribal clients. I am always excited to see Mr. Tinker on anything, because Mr. Tinker was an intern at OIL's when he was a law student at TU, and I see that on in this session we have a number of former OIL's attorneys. We also have some other former interns with us. I got Ms. Thompson's email today, and I will be contacting you about what OIL's has seen with some probates and stuff. So I am not as technically advanced as I would like to be. Usually I set it up so I can see what the next screen is going to be, but I am just doing it the best way that I can, is to just you're going to see what the next slide is on the next, over on to the left. Okay. So, like I said, what I want to talk about today is cultural competence in tribal practice, primarily in tribal courts, because we've got so many more attorneys in tribal courts now with the McGirt. The Oklahoma Rules of Professional Conduct, Rule 1.1 is about competence, and Rule 1.4 is about communicating with your client. One of the things that I think is important, and one of the things that I really try to teach in the classes that I have, is talk about the history of the tribes of your clients. If you're going to be practicing in one particular court a lot, do a little bit of research and read just a little bit, at least, about the clientele in the court that you're going to be in. Dr. Blue Clark, he wrote this terrific book, Indians in Oklahoma, and Renard Strickland has a book talking about Indians in Oklahoma. I recommend that, somebody who's going to be practicing in tribal court, get a copy of that, or, go check it out from the library. And if you're going to be practicing in a particular tribal court, read up about that tribe. Identify practical approaches. So I'm going to tell you a little bit about some of the ways that the oils attorneys over the years we have learned to communicate and work with clients in tribal courts. And then just, we were all taught in law school that, hey, we gotta be loud and strong, and we gotta, you advocate for our client in the best way that we can. And sometimes we feel that it's just, being loud and, getting in the other attorney's face and stuff. And yeah, I think sometimes just having a little humility and, recognizing where we as the attorney come from, where does our client come from, and just being willing to learn something that you're not usually acquainted with. Okay, so this just kind of goes over again that we're going to talk about competence and effective communication and such. The first thing that I want to do, and if there is anybody who already knows all of this, it's this audience, is that there are 38, not 39, sovereign tribal nations here in Oklahoma. We get 39 because we've got some groups that are part of larger groups, larger tribes. The Uchis, they get their services from the Muskogee Nation, the Delaware Nation, or not Delaware Nation, well, Delaware Tribe, the United Band of Katuas, United UKB, United Katua Band of Cherokee Indians. They are all related within the Cherokee Nation, and I don't want to talk about that because there's a lot of, talk about that and everything, and it's not my it's not my place to talk about who's who in that tribe. Each of these tribes have independent legal systems, and even if the tribe doesn't have a tribal court, they do have a constitution. They've got some type of legislation, some type of code. There's ordinances. There's different things that are considered law within that tribe. And I think it's important that if you're going to practice in a tribal court, if you're going to represent somebody using tribal law, you better have read the Constitution. You better have looked at the code and get an idea of what the law says, what the legal system is, and that with that particular tribe, they're all different. And that's the first thing that our attorneys do is, they're looking at the code, looking at the constitutions when they're working within a particular tribal court. Each tribe has their own distinct histories. I, travel a lot and I meet lots of different people, and people are fascinated by Oklahoma. We all live here, and I always tell people that I just feel like all of us here in Oklahoma, all of us Oklahoma citizens, we are just frogs in the pot of boiling water and stuff. That there's all sorts of stuff that's going on here in Oklahoma, and we're just the frog, and we're like, oh yeah, okay, that's happened. Yeah, okay, we're 50th in the nation. Yep, that happens and stuff, and we're just sitting here, and it all happens around us and everything. But one of the things that, they want to know about tornadoes. They want to know about, Route 66, but they always want to know about Indians. And when they find out that I'm Indian, you know, I have had people ask me if I lived in a teepee. I have had people ask me, do I ride a horse and stuff? And I explained to them that, I drive a car and I live in a house in Oklahoma City. And so, I grew up in a house in Lawton and we had a car when we were in Lawton and stuff. So, there's misconceptions about the history of tribes in Oklahoma. And I think it's just so important that um, you do some, you know, open your eyes, I guess, and do some research and have an understanding of the tribe that you're going to be working in. And like I said, I am just preaching to the choir right here. All of you know this, but if you come across somebody that, you're like, I think you need to do a little bit more research and understand where you're practicing. I've had a judge tell me before that they were swearing in somebody to practice in their court, and they couldn't pronounce the name of the tribe when they were being sworn in. And the judge asked them to go outside and why don't you do a little research and make sure that you understand the tribe that you're practicing in and make sure that you can pronounce the name of the tribe. You're going to do your clients a much better service if they uh, trust you that you know who they are and that you can say the name of their tribe. Okay. Like I said, I hear a lot of questions about being tribal and being Indian in Oklahoma. That question that came up earlier with Attorney General Weisner and Mr. Tinker about, do I say Indian? Do I say Native American? Well, what I tell people and what I tell my students is that first and foremost, I consider myself Kiowa. So if you're going to address me as, what is my identity? Well, my identity is that I'm Kiowa. Now, my daddy's white, so I am also white, but I also understand the history of my dad. And let me tell you, we got some history in our family, my dad's family that's from Arkansas, and they belong to some groups that I am not happy that I have that history in my bloodline and everything. So, you know, Oklahoma, histories and who your family tree is complicated in Oklahoma and stuff. And one of the things that I'm coming across, and like I said, I'm Kiowa, and we're trying to deal with, what do we want our blood quantum to be so that do we bring in more people into the tribe? Do we keep it as we are and everything? And I tell my students all the time that it's not about blood quantum. It is absolutely not about blood quantum. What a tribe wants to do and how they want to define their citizens, that's absolutely up to them. They are the ultimate arbiters of who their citizens are. But I tell my students, I tell my child that it doesn't matter what somebody's blood quantum is. What matters is their culture. And do they embrace their culture? Do they dance? Do they go to ceremonies? Do they go to an Indian church? Do they, spend time with their grandma all the time? It's not about the blood quantum. That doesn't define whether you're Indian or not. It's whether you embrace that culture or not. And sometimes, it's not even whether you embrace the culture. It's a matter of do you have the ability to show that you are descended from somebody who's Native American. Some tribes, you're going to have the blood quantum. Some people, they need to know what their heritage is, what that CDIB paper says, because they might qualify for other types of services like Indian health and everything. So, historical context matters. Um, I have just grown up with people asking me all the time, Indians, they just have it in their blood that they're alcoholics, and that's just part of who they are. And, you got to be real careful about drinking because, Indians are going to become alcoholics and stuff. Well, for a long time, I didn't know how to answer that and stuff. And as I have been able to do more research, do more studying, learn so that, I can, teach these law students at OCU and at OU, is that you got to understand the history of what, tribal members have been through. Tribal members were removed from the eastern part of the United States. All of you know this, and Professor Miller was talking about this. Where tribes were removed from all over the United States. And Nikki Lindsay and I gave an ethics presentation Friday over at the Chickasaw Bar Association, and we had people come up afterwards and tell us that we never understood why the five tribes were called civilized. And I told everybody, don't say civilized anymore. It's five tribes. That's the more polite way to say it. And Professor Miller explained it, is that they were there for 300 years, living with Europeans and building houses, building schools, building towns and such. And they understood what fee simple meant when they were negotiating and stuff. And they had what they thought was fee simple land in Georgia and North Carolina and such. And it was taken away from them. And then they were moved all the way across, to Oklahoma and everything. So, that removal, the boarding schools, my grandparents were in boarding schools temporarily. My grandmother wasn't in there very long, and my grandpa ran away from boarding school. I think it's at Rainy Mountain, and they ran away from boarding school, and they were able to come home and stay at home in Hobart. So I heard the stories about the boarding schools. My grandmother was an excellent seamstress, and I thought, we should just learned it from her mother and everything. And one day I was watching her, and she was repairing some buttonholes. And I said, Grandma, how'd you learn to do the buttonholes? Who taught you the buttonholes and everything? And she said, when I was in school, we would do that all day long. She said we'd have a big strip, and she said we'd have to start at the top and then all day long make buttonholes and everything, and make sure that they were perfect, and they had to be perfectly aligned and stuff. I learned that from my grandmother. And then, allotment, just the idea that, my family, they were, fishing and hunting and living. My grandmother was born, on, Elk Creek she said she was born in a canvas tent. That's what they were living in and everything. So, lone wolf, monkey, they had the ability to be able to travel from, Elk Creek, and they were both, I tell, people that my ancestors, my grandparents, I remember very well living with my grandparents and talking to my grandparents and everything. Their grandparents, who they lived with and talked to and learned from and everything, their grandfathers were warriors and went down to Texas, and they attacked settlers in Texas and fought them for their lives because they wanted to make sure that they were going to live, and they were worried about these settlers and everything. So that memory, those types of memories are, very present in all of our lives. We all have, our grandparents who told us things about their grandparents and everything. And, some of the stuff was good and some of the stuff was freaking scary, what they had to deal with and everything. And then just the termination policies, just the tribes have fought so hard just to be here. And the federal government has just gone through these, waves of, oh yeah, well, we're gonna help you, get your tribe reestablished and everything. And oh no, we don't, we want to take that away again. And oh, we're gonna help you, with self-determination and stuff like that. And oh no, we don't want you, your reservations recognized or something like that. So it's just this roller coaster that, on top of, the history of removal, the boarding schools allotment, these laws that tribes and individual tribal members have to deal with. It's just, you know, it is generational trauma. It's generational trauma. And the um, inability to have the stability that non-tribal members were able to achieve by coming in on land runs and such and being able to have a place to make a home and still have that home, 100 years later and everything. Tribal members have not had that stability and everything, and it does, it's causes an effect on children and causes different stresses and everything. So that's a big old long answer that I give to people when they say, well, don't Indians are just alcoholics, aren't they, and stuff. And I said, well, let me tell you, no, no, no. There are a lot of great, 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 great Indians out here, and let me tell you what we've accomplished and everything. So, all of that, attorneys who are practicing in the tribal courts, they got to understand that all of that has had impacts on, their clients today. Tribal members, oh my gosh, they have so much mistrust of an organization that comes in and says, "Oh, we want to help you," and you're like, "Yeah, the BIA is supposed to help me," and I have a lot of issues with that and everything. You've got to be able to pick up on, silent communication and nonverbal communication. One of the things that we have learned going out to engagement events and everything, we every month go out to a Choctaw Community Center. And we also go out to Muskogee community centers. We have these great relationships and partnerships with the um, um, probate departments of both of those tribes and everything. So we go out on a monthly basis. And it's our experience that we'll get our table set up and everything, and it looks good. We've got all sorts of swag that we're giving out to people and everything, and they'll just sit across the room and look at us, and we'll smile. And I know that sometimes they're like, "Who's that woman over there smiling at me?" And they'll just kind of look at us and everything. And then we'll pack up and we'll go and have given away a little bit of swag and everything. And we'll go the next month, and they'll come over and they'll walk by and they'll pick up some brochures real quick and stick it in their bag, and they'll walk away and stuff. And then the third time they'll come over and they'll say, "Who are you?" tell me who you are and everything. And then I'll say, oh, I'm Kiowa and everything. And well, who are you? I'm Stephanie Hudson. Well, are you related to the Hudsons over in blah blah blah? And I'll go, no, I'm not Choctaw. That's my daddy's name. My daddy is white and everything. And they'll go, oh, we're sorry, but that's okay. I'm glad you're here. I'm glad you're here and everything. And by the fourth time they're coming over there and they're like, hey, we're glad to see you here again. I've got a problem. I've got a problem with, my land's not brought up to date and I need to get it probated and everything. And, that's, that mistrust that tribal members have about people who are coming in and saying that we're going to help you. And, that's just something that, attorneys, they need to understand. Um, One of the things that we try to tell people about tribal court structures is that if you're federal court is very strict. There very specific things that you have to do. Arvo knows that. He's always explaining about how things need to be done and stuff. And state court, there's certain ways that the state court judges do. Some state court judges are very formal, some are very relaxed. We have to train our new attorneys on, this judge is going to do this judge is going to do that. You're going to come out with the same result, but they're going to do things differently. When you're dealing with tribal courts, one of the things that we like to explain to people is that sometimes the tribal court judges, they don't act so much as the person who's going to make a ruling, you win, you lose, and such. That's one of the things that we talk about with our clients is that, if you go to court, somebody's going to win, somebody's going to lose if we have to go to trial and everything. And I can't guarantee you what's going to happen and everything. I got kind of an idea, but I'm not quite sure. Whereas, I've seen a lot of tribal court judges, they'll get the people up there and stuff. And I've even seen some judge go, and I literally have, like, it's like, I know who your family is. And your grandma wouldn't be happy about you, running around doing this and everything. Let's figure out what we can do to try to, help you out and everything. And the kids usually, oh, and everything. And, the judge will say, hey, you pay attention to me and stuff. So, that's one of the things that I think, you know, attorneys need to understand about tribal courts now. With the five tribes, they're getting very sophisticated and stuff. They got huge dockets and everything, and they may not have that ability to have that rapport as much anymore as that we did in the past. But there's still tribal courts that do, and the larger courts, they've got little programs that are good. The healing to wellness courts and the veterans courts and stuff, those are courts where it is more of a restorative style and everything, and I'm excited about courts that are doing that. Okay, competence. There, one of the comments in Rule 1.1, one of the comments talks about yeah, well, basically 1.1 says you better be competent. You better be competent. You better know the type of law that you're practicing. You better, know the court that you're going to be working in. You have to, understand and, provide good representation to your client. But one of the comments says that if this is an area of law that you don't usually practice in, it's okay if you get somebody who has practiced in that area who's going to help you along with that. And it's okay if you do your research and you learn about this area of law that can help with, meeting the requirements of 1.1 with your competence and everything. So like I said before, read tribal code, learn court customs, understand local protocol, talk to some of the attorneys who practice there regularly, find out, what's going to happen when I get into court and everything, research case types. There's not, you know, the the case reports and everything, or the reporters and everything. But you can talk to other attorneys and find out, what's the judge usually do in these types of cases and stuff. Okay, so client communication. Um, to meet the requirements of Rule 1.4, your communication must be effective. So, what does it mean to be effective? You need to understand the client community that you're working in. If it's tribal, is this somebody who does meet the blood quantum requirements and they got picked up in Tulsa for something? And are you going to need to be concerned about cultural expectations as much? And that's okay if that person isn't as cultural as some others are. But then what if you have a client who, they're elder and they go to their ceremonies quite often and such. They're a little bit more humble. They, are less willing to talk about some of the stuff that's happened with them and everything. So, you may need to take a little bit more time to talk to them. And I see a lot of attorneys, kind of rushing through talking to some clients and everything. I tend to do it sometimes because I'm just in a hurry and we got to get this engagement all done and everything. And you just have to adapt to what the particular situation is when you're talking to your client. Create safe dialogue. One of the things I have to learn to do is when I'm talking to my clients is to slow down with what I'm saying, make sure that I'm talking on a uh, eighth grade level if possible, and not use big words. Expungement's a big word that always throws when we're running some sort of program to make sure our products are eighth grade level. Expungement always knocks us out of there and everything. So, explain the processes clearly, go through it step by step and everything. I gotta tell y'all, one of the people, and I saw him on here, I hope he's still on here, one of the persons that I learned a lot from by observing and listening to him talk about, things. And he's helped me through, things that I've been like, I'm not sure, I'm a new attorney. I'm trying to figure this out. It's Albert Gezzi. He is a person who will spend a lot of time talking to somebody and really does try to understand what's going on with that situation. And he's somebody that would be a star on Rule 1.4 and everything. So I always appreciate what he taught me. Silence. That could be that they're showing respect to you because you're an attorney. Um, they will tell you stories, and a lot of clients will tell you the story. You say, "What are you here for?" Well, back in 1974, I met this person, and you got to try to figure out. I've only got an hour to get some information from this person, so let's see if I can do some active listening and try to guide them in a way where I can get as much information as possible. Um, you know, uh, One of the things that we've learned talking to our clients and everything is that they'll, go in a circle with, what it is that they're trying to figure out and everything. And what we are working on in our office is sometimes a legal problem. It presents as a legal problem, but once you start digging and going back and trying to figure out, there's some sort of other issues going on within the family and everything. And we've got these community justice workers that we're training that We want them to be able to identify the legal problem, but figure out what caused the legal problem for them to be here. The best example that we have is the grandma who called us and said that, they're taking my grandkids away. I got a guardianship over them, and ICW is here taking away my kids. Well, why are they taking away your kids? Because they say my house is unfit. Well, why is your house unfit? Well, I got a big hole in my ceiling. Well, where the big hole in the ceiling came from? It came from the ice storm that we had and burst my pipes and made a hole in my ceiling and then made a hole in my roof and everything. Well, why have you not had your house fixed and everything? Because it's still in my mom's name and everything. Oh, well, we can fix that and everything. So it's this process of, trying to help them with multiple issues sometimes. Okay, so we got common pitfall. Let me get this back over. Okay, common pitfalls for Native attorneys. Get rid of these. That's what happens when you got a touch screen. Okay, interrupting the storytelling, mistaking silence for disagreement, rushing decisions, overuse of legal jargon. That's what I just talked about and everything. One of the things that we've been doing some training on is, when we've got clients who they've gone through trauma. We don't realize that, some of the things that our clients have gone through, it's not just sadness, it's not just depression and everything. It's real trauma that's, changed how their brain is working and everything. So, what we've got to do is try to make sure that, when we ask questions that we're not, re-triggering everything that's happened, to figure out ways to get information from them that, doesn't make them describe in detail something that's happened to them, over and over and over again. Is that we got to try to figure out how to get the information as quick as possible without, like I said, harming them again. If you're a new attorney and you want to try to, build a practice in a tribal community, attend events, go to powwows, go to, uh, you know, um, you know, community fairs and stuff, spend time within the community, volunteer at clinics, come with oils. We've got a new grant from the OBF, the Oklahoma Bar Foundation, where we're going to be doing a whole lot more engagement in tribal communities next year. And we're going to be trying to engage with pro bono attorneys within the local communities. So if you live in a little bitty community and oils is going to be there, we might be calling you and asking you if you can come help us out for a day and do some work with some other community members. So um, holistic approaches to justice. Like I already talked about, some judges are really good about just, getting on the party's level and talking to them, restorative practices. The Citizen Potawatomi Nation, they've got Bert Patadol out there, my pal Bert. He does a sweat lodge every week, I think, and he has his people in his classes come and they have to make dinner together and then they have to sit and talk with each other and then they can sweat if they want to and everything. And he gets good results from the people that he's working with. Advocacy with cultural context. If you're working especially with family cases or juvenile cases, what you want to do is see if there's some way that it's going to affect the way that the family lives together, the family work is working with each other. One of the things that I've been telling people lately, and my kids in these classes, they don't understand who I'm talking about. I always say, we weren't meant to live like Leave It to Beaver. And they look at me like, who's Leave It to Beaver? And I always have to explain Leave It to Beaver was a show in the 50s that I watched when I was a kid in the 70s after school and stuff. And it was a mom and a dad and two kids, and they lived in this nice big house and everything. And that house had enough room for some cousins and grandma and grandpa and everything. And that's truthfully how a lot of people live. And it doesn't matter whether you're Native or Latino or Black or white. There's a lot of us that, live with multi-generations. And, I truthfully think that, that's the way that we're supposed to live. And I always tell them the Leave It to Beaver kind of life, that was kind of the, kind of off from the way that we do things and stuff. So, think about how your clients, how they live and everything. Listen, if this is something that attorneys, don't like, is when your client says, "Oh no, that's not the way that I said it. That's not the way that I understand it. My cousin says that, you need to be doing it this way and everything." And it's real easy to say, "Well, your cousin's stupid. You know what? I'm not going to listen to your cousin and everything." And I think instead, what the better way to do is to say, "Oh, tell me about what your cousin said," and let them talk and everything, because they're going to be more likely to follow your advice if you're listening to them. If you're cutting them off and discarding what they say and everything, they may not trust you. And just listening to them, being willing to, if they correct you or something, being willing to say, "Okay, I hear that, I hear that." That's all you have to say. You don't have to, say, "Oh, I'm going to do that," or something. Just say, "I hear you." That's one of the things that, I've really learned, is I hear you. Oh, mistakes will happen. We always tell our interns and our new attorneys and everything, we can fix almost anything. Almost anything. Every once in a while, something will come along that we're like, "Oh, darn." Well, I don't know what we're gonna do, but we'll figure it out and everything. But things happen, and we miss a deadline on something, and somebody got mad about something. Well, we're just going to fix it. We're just going to talk to them. We're going to get it all figured out and everything. And I always tell them, do not be afraid to come and tell me something. Do not be afraid, because when you don't tell your supervisor about something, that's when things are going to go crazy and stuff. Is, seek guidance, be willing to adapt, listen to what your clients are talking about and everything. So basically, this is your 1 hour of ethics and everything, so that you can make sure you can check your box that you got your ethics. I'll tell you another way to get your second hour of ethics if you need it here in a minute. So, rule 1.1, competence. You have to be competent to practice law. And if you're going to practice tribal law, one way to be competent and show that you're competent is, you know your tribe, the tribal court, the tribal community, what the tribal law is and everything. Oh, okay. I'll come back to those here in a second. Okay. Communication, whatever community you're in, there's going to be different norms and stuff that you're going to have within tribal communities. And having good communication with your client, that's the number one way to build trust with them, is just listening to them. Take the moment to listen to them. I know we're all so busy. We've got the next meeting we've got to get on. We've got to get on the Zoom. We got to get to court. We got to go get our kids at school and stuff. But just find the time to be able to listen to your clients and everything. And, one thing that, I really, really do believe is that practicing law in tribal court, it really is a privilege. It is the way to honor the sovereignty of the tribe. It's a way to show that you respect the culture. Um, yeah, all of this about who has the jurisdiction over these particular offenders and stuff. Somebody along the way got their feelings hurt about something and has some trouble with, recognizing tribes and respecting them and everything. And, we'll move past that and everything. But, like I said, I'm preaching to the choir is it's important to, practice in the tribal court if you have the opportunity to, because that's what sovereignty is built upon. Sovereignty is built upon, the jurisdiction that we exert over our land and making sure that our children we're protecting our children, and if we can make sure that something's going on with our child, can we go to tribal court to deal with it? Can we do an adoption there? Can we do our divorce there? Can we work on our custody thing within tribal court? And just communicating with your client and being competent. That's the best way to serve your client responsibly. So I think, thank you. And aho. And we'll see if anybody's got any questions. Oh, yeah, here. Oh, somebody's got that on there, offering advice. That's it. That's the one that I was looking for.
Yeah, Stephanie, I've been posting some of these rules that you've been referring
Oh, good. Thank you. Thank you. Thank you.
just for the actual legalese. And
Okay.
this last one, I think, just to kind of get your thoughts about it, because and that has to do with the role of a lawyer being a counselor or an advisor.
Mm-hmm.
And I think that's rule 2.1. And basically, it says lawyer and counselor. What is involved with being a counselor? Because I think a lot of us, we get trained in the law, but we may not be very good counselors. And
So one of the things that I always talk to students about is, when somebody's in distress, when there's something awful has happened to them, there's a handful of people that they'll think of to call when they're in distress, and one of them is going to be a minister or clergy that they're going to reach out to. If they've got some sort of medical emergency, they're going to look for the doctor and everything. And then lawyer, if something, something's happened to their kid's got arrested or something like that, or they're they're needing to get guardianship over their grandkids and stuff. It's like, like I said, Leave It to Beaver, they those kind of shows and everything. They'd be, oh well, call my lawyer, call my lawyer. Who of us has a lawyer? Arvo, you're my lawyer. If I'm going to be, we go, Arvo, I need help. But that's the when I think of a counselor, I think of somebody's going to call in distress, and you may not be giving them legal advice. What you may be doing is you may be just kind of guiding them through some life advice or common sense or something like that, just to get them to a point where we can make a decision about, is there a legal issue here that we need to deal with.
I think one of the most difficult cases I had a long time ago, and it kind of touches on this, is there's often this I don't know what you would call, maybe a presumption or even a default that, okay, we're going to court, we're going to litigate this, we're going to fight.
Yeah. Oh yeah. Yeah.
And sometimes that's not the best thing to do. And if you look at this, if you look in the comments, this last in the chat, the last comment on rule 2.1 kind of talks about some of the things that you touched upon. Maybe it's better to stay out of court, to resolve it. It's going to be less expensive.
It's much better. It's much better if possible.
You're not going to end up having a winner and a loser, and now the family split in half, and there's bad feelings, and that sometimes is contrary to what lawyers are out there looking for. Is they're looking for I need to find a billable hours. Now, I don't do that because I work for the government. You don't really do that either.
Mm-mm.
But those that are in private practice, it's like, okay, I've got to pay my own bills. Am I
You
going to
know,
steer this
one
person?
one of the things that I think about is, the volume. If you can kind of make a choice, is do you want to work with one client where you're going to bill 200 hours or something like that, or would you rather work with a number of clients that you're going to have some steady income from them, and they're getting it all resolved and stuff in other ways. What I would be afraid of is the person that, you've billed 200 hours on, are they going to ever pay it? Are they going to have the ability to pay something like that? Whereas, if you're having a number of clients that, you're billing them, a few $1,000s. I don't know how much attorneys charge anymore. We don't charge, but if you're billing them, a few $1,000s to help them out with $5,000 to help them out with the divorce or some uncontested divorce or something, they're more likely to be able to come up with that.
Yeah, and it's interesting because this comment kind of ties back to what you mentioned before, this communication where it says, if a matter is likely to involve in litigation, it may be necessary under Rule 1.4 communication to let them know you've got alternatives, alternative dispute resolution. It might resolve your case in a less expensive way and maybe a better result. So there's essentially a duty to even offer that as something other than going to court and taking a long drawn out process that will maybe not, in some cases, end up with the best end result. There'll be a winner and a loser, but then sometimes that, especially in the family context, that sometimes is not the best thing.
I really do believe in the family context that if there is an opportunity for alternative dispute resolution, that's the best way to do it, because once you get these families in court and everything, it's very hard to get them back talking to each other again. Whereas if you can sit them down with an alternative dispute resolution result, at least they're going to be able to walk out of there knowing that they had their voice heard. Whereas, people think that they're going to get in front of the judge and I'm going to tell the judge all of this and all of this and everything. And the judge ain't going to listen to any of that. Whereas the mediator will. The mediator will listen to all of it.
Exactly.
Mhm.
All right. Are there any other questions anybody has about the cultural competency in serving clients in Native communities? Let's see. If not, I think we've satisfied. We've gone over our required time here. So we're right at about, close to an hour for our ethics. Again, we want to thank everybody for joining us this afternoon. I especially like to thank all of our participants who shared with us their knowledge. It's really hard to think of the fact that, it seemed like McGirt just happened and it's already 5 years after the fact. I remember walking out in the backyard and it was a sunny day and I got the news across my phone and I about fell over. And so again, it's the push and pull, and we win one, and then then we have to kind of face the consequences. Unfortunately, I've seen this over and over again, and I don't know why it is this way, but it seems to be this way. It's like when Native people are successful, that is sometimes the most dangerous times for a variety of reasons. When we're successful, right before statehood, the five tribes are very successful, and then we're hit with legal challenges. There are other tribes that were militarily successful, and then like some of the tribes on the western side of their state, like our tribe, they are hit with something else. So we have to be knowledgeable and be able to use our best efforts to navigate through that process. But the fact that these legal concepts that are older than all of us combined, now come into question. It just makes you wonder. You were going to say something?
Yes, Linda reminded me that I was going to tell everybody how to get 1 more hour of ethics. Okay, if you need 6 more hours of CLE, and if you need another hour of ethics, or your friends need 2 hours of ethics, go to the Oklahoma Bar Association, the CLE page, and the Indian Law section. We've got the webinar up now that we worked on a couple of weeks ago. The webinar is up. If you're a member of the Indian Law section, the OBA Indian Law section, the CLE is free. The webinar is free, and it's 6 hours of credit, and then there's 2 hours of ethics on there. Now, 1 hour is going to be what I kind of did, but then there's another hour of a judges panel, practicing in tribal court, the view from the bench and everything. So you'd be able to get, well, you do that whole CLE, you'll get an extra 1 hour, and then they'll roll over to next year, and you'll have half of your CLE for ethics for next year.
All right, great. Appreciate it, Stephanie. And okay, so our final word is the one tribe in Oklahoma that is not federally recognized, that often is included in the 39 tribes. I think there was a total of, some 60 or 70 tribes removed, and some of them got swallowed up into others. But I always see this all the time. 39 federally recognized tribes. And I think, Stephanie, you're the first one I've heard say recently, it's not 39, it's 38 federally recognized tribes. The one tribe that usually is included in that number that makes it 39 is the Yuchi tribe. Y-U-C-H-I or E-U-C-H-E-E. I've seen it spelled both ways. So that's the final word. And again, the train's going to leave the station, folks, here. So if you don't send me to Oklahoma Indian Bar Association at yahoo.com, 3 things. Number 1, your name as it appears on the bar rolls. Number 2, your bar number. And number 3, the 5 words that we gave during the seminar, then you may not get your credits. And it'll take weeks, and believe me, we'll send it in and try to push them. But every year, you're not going to probably know before the end of the year. I'm just letting you know right now. But they'll give you a little bit of leeway. So make sure and send that in, and don't be the one that's going to hold up everybody, because then I'll get phone calls saying, hey, I haven't heard anything yet. And I'll say, well, that's because so-and-so didn't turn in their and we're waiting on them. So,
and I can vouch for that he does get all those emails from, I don't have my bar credit on there, I don't have my CLE credit on there. So get it all in today.
Yes, that we would really appreciate that. And again, thanks to all of our presenters, and thank you for everybody for tuning in. We'll probably have a video replay, and we'll have to see if our account has worked here and it's recorded. If that's the case, we'll probably replay this before the end of the year. If you want to let somebody else know that wasn't able to join us today and is able to satisfy their CLE requirements. All right, we'll go ahead and sign off now.
Thanks, Arvo, for putting this on.
All righty. Thank you. Thank you to everybody. And we'll go ahead and conclude right now.